to be wrong declaration, and she has just made her entry. Indeed, Bishop, before Madam Jane Mensah's arrival, we have earlier also seen the arrival of President Mahama himself, who is the petitioner in this case, but also he was escorted by his running mate in the 2020 presidential elections, Professor Jane Nana Opoku-Agyeman. Both of them are here. Did you notice the arrival of other top members of the NDC or even the MPP?
Yeah, the MPP, on the side of the NDC, we've seen the chairman, Mr. Ofuchampofu. He's also entered. And again, on the side of the MPP, we've seen the chairman of the party, that's in the person of Mr. Freddie Blay. And then General Secretary John Boadu has also entered, and some party stalwart like Mr. Hackman Owusu Ajiman is also entered. And on the NDC side, MPP side, the lawyers have also lawyer Kotampao, Frank Davis, Sheila Menkampremu, Dr. Kodudapa, Nana Yaopong, and then Mr. Kokwesrifi. These are the lawyers representing the MPP. They've all entered together with the NDC lawyers as well. And the NDC lawyers have seen Mr. Tony Little. They've also entered already. So we're going to see another showdown. But as we saw the other time, we're not certain whether the 7 judges that sat on the case and they're doing the amendment are going to be the same judges that are going to sit on this case. Because the first last week we saw the Chief Justice himself, and then we saw Justice Tokonu, and then Mariam Owusu.
And more officials are arriving. We're currently seeing Mr. Kojo Ponkroma, who is currently the acting Minister for Information, making his entrance to the Supreme Court. In fact, he's one of the spokespersons for the, well, it's Nanado in this case. And so he has just made his entry to the Supreme Court. But Edward, we're talking about why we are here. And you got to the point where you spoke about President Mahama being uncertain about the results as were declared by Madam Jane Mensah on the 9th of December 2020. And so what's he asking the court to do for him?
He's asking the court to do a rerun of the 2020 election, because based on their calculation, none of the parties or none of the candidates got a majority votes in terms of 50%, beyond 50% that the constitution declares, and they are claiming that Nanado got 49% and he had 47%. So none of them won the election, and therefore there should be a rerun of the 2020 elections.
Again, this is not the first time we are witnessing an election petition. There was one in 2013 which had to do with the 2012 elections. What's the significant difference between what we are seeing now and what we experienced in 2013?
The first interesting difference is that, the 2012 election petition, which started in January 2013, we saw the current President Akufo-Addo on the other side as a petitioner challenging the then incumbent, former President Mahama, that he won the election per their calculation, and therefore he was seeking the court's mandate to declare him the winner of the elections. And then today we've seen the reverse. And interestingly, but what stands as it is, the status quo, is that the Electoral Commission is still in the matter, but this time around is not in the person of a former the ex-EC commissioner, that is Mr. Kojo Farijan. This time around it is Mrs. Jane Mensah, who is also standing in for the EC. So that is a major difference. And then if you look at in terms of the judges that were impaneled, we had 3 ladies among the 9 judges that sat on the case. There were 6 men, and interestingly, most of them had gone on retirement. Okay,
and we are currently experiencing more arrivals of some of the dignitaries. I believe this is the Deputy Attorney General.
Former Deputy Attorney General, that is Godfrey Dami.
Well, he's acting, is he not?
No, he's not.
He's not? Okay, yes. All right. So, but Mr. Godfrey Dami, who is the former Deputy Attorney General, also making his arrival to the Supreme Court right here. And I recall that in 2013, when we were covering the 2012 election petition, even though he wasn't part of the legal team, he was very, very instrumental anytime the MPP came to court. And he's been a lawyer for a long time now as well, and also has been a Deputy Attorney General for the past 4 years, from 2017 until 2020. So let's return to the substantive matters again. We're talking about 2013 as against 2021 and the similarities and the differences. We recall that you just spoke about 9 judges. On the last occasion when the court sat, we observed that there were 7 judges. Again, we are told that the fact that the Supreme Court is hearing the election petition does not mean that all other cases at the Supreme Court will come to a halt. Could that be the reason for which we've seen a reduction in the number of judges on the panel?
Well, one can hardly figure out that might be the reason, because I think that if you notice there's a new CJ, that's Chief Justice. So based on his experience, perhaps because he was part of the panel that sat on that case, that when we had 9 judges in the person of Justice William Atuguba, Justice Badegbe, Justice Julius Ansa. We had Justice Adinyira, that is a lady there, and Justice Owusu as well, also a lady. And then we had Justice Maida Kutubanfo, who was also gone on retirement. And then we had Justice Eniyabua himself, that's on the case, Justice Doste, and then Justice Bafuboni. So based on that experience, perhaps you might have talked through and realized, look here, it can be handled by 7. We don't know whether today they're going to maintain the 7 that sat on the amendment issue, because we're hearing that could be another issue altogether. So we're waiting to see the panel that will be announced by the courts today. But if you look critically also on the side of the NDC, the lawyers that led them, we've seen Justice lawyer Chachi Chikata also is still in the legal team, Tony Lita still in the legal team. Now we've seen lawyer Edwigi as well, but he was not instrumental. We saw Dawuda at those days.
So again, there's a significant.
And then we're not seeing the famous face lawyer Addison.
Oh yes, lawyer Philip Addison conspicuously missing on this occasion. But at the point, well, we'll talk about those issues later on. But what I again want us to look at is the fact that in 2013, when the 2012 election petition was ongoing, there was the petitioner, which was the MPP on the one hand, and President John Mahama on the other hand. Then you had the EC on the other hand. Then the NDC filed to join the suit, and so you had 3 respondents on that occasion. On this occasion, there are only 2 respondents. Do you believe that this will contribute to perhaps quickening the pace at which proceedings will go on in court?
Exactly so. I think so, because the more you have people, they might be called upon to come and testify or give an evidence of whatever they have. So I think that is going to help in making sure that the issue is dealt with smoothly. Because remember, and during the 2012 election petition, we saw, even when we talk about the NDC, we saw Mr. Asiodun Ketia, the General Secretary of the NDC, being called upon. And there was a famous statement that he made that, my Lord, I'm not a lawyer. I remember there was a question put in by Mr. Philip Addison.
Yes, I remember. I recall very well.
Yes, my Lord, I'm not a lawyer. So if the MPP is not coming on board this time around, it's going to smoothen the pace in terms of quickening the pace of but let's not forget that the CG has announced there's going to be 42 days of running this case. And so, unlike we had 8 months. And Abdul, let's not forget that when we have these cases going on, one, the signal to the rest of the world is that, one, Ghana is a democratic country, that we uphold our institutions, that know that, look here, it's not good to use violence to sort out our issues. We have to go to the court. And more importantly, also give confidence to the investor community out there that once this is being done, if it comes to invest in our country and there's a problem,
we'll go to court and not to resort to violence.
Exactly. But the key issue is that how long, if it drags on, though they will say that the accused of justice drags on, but if it's dealt with in a quick pace like we're saying, it's expected 42 days, it's a signal that, look here, we're not going to repeat what we did the last time. And let us not forget also, Abdu, what we did in 2013, which is the election petition for 2012, also sent a signal to the rest of Africa, and Ghana was regarded as a beacon of a democracy in Africa. And so when we did that, on the heels of that, Kenya also followed suit. And this was very instrumental. It was a landmark case where, for the first time, Chief Justice David Maraga and the people who sat on the case overturned the verdict of the people in terms of the election results, and declared that none won the election. Therefore, there was a call for rerun. And then they did a rerun, though President Uhuru Kenyatta won it again. But it was a very interesting case. We saw another one filed in Zimbabwe, but that one, the incumbent, the one who was declared president, Mnangagwa, was retained. So it's a very interesting time and period that we are in, and as a continent, even though coronavirus has reared its ugly head in our midst, we're still showing that, yes, this wind of democracy is still blowing through our part of the world, and we have put our institutions like the Supreme Court. Let's not forget that our emblem is freedom and justice. So.
Exactly, and if you just joined us, this is GBC's coverage of Election Petition 2020, and the lawyers for the respondents, so we've seen them come in, the respondents in this case, the EC as well as the lawyers for President Akufo-Addo, and then we've also seen the arrival of President Mahama, who is the petitioner in this case. He arrived in the company of his running mate in the 2020 elections, Professor Jane Nana Opoku-Agyeman. We've also seen the lawyers of different lawyers come in, perhaps to observe and to learn from this as well. Believe us and trust us here at GBC, we will bring you up to speed information to the minutest detail as and when it happens right here at the Supreme Court. But I'm here with my colleague Edward Nyakon, who was very instrumental in covering the 2012 election petition, which happened in 2013. He comes along with a lot of experience from the past as well. So Edward, let's get back to issues of contemporary times. So when we came here to court the last time, which was, I believe, on Thursday, what were the issues all about? What did the court address? What did the petitioner seek for? And how was it granted?
Yeah, the NDC petition that was filed challenging the EC in terms of the declaration that President Akufo-Addo had won the election and they are calling for a rerun. In that petition, we're told that they made some errors, so they came to the court to seek for the court's approval, to be given the chance to go back and do amendment of the case, in the sense that instead of saying that they are calling for a rerun between the NDC candidate, President Mahama, and President Akufo-Addo, they erroneously made it that it's going to be between the President Mahama and the EC, which is the first respondent. And so they sought the court's mandate to go and do that, and their plea was granted. And secondly, the NDC also was asking the court to televise these proceedings live, which, interestingly, the Supreme Court had already done that prior to their coming to the court. And so these were the major issues that came up, even though in terms of the going back to amend their errors that was on their petition, the EC lawyer protested, indicating that it should not be granted that request. But after going into the chambers, the judges came back and said this issue would not, if they amend it, it's not going to affect the substantive case, and therefore they should be allowed to go and make the amendments and return the same day at 4 p.m. And they made a deadline, as we're told by the NDC lawyers. So today we're going to see how the case, if everything is okay, we're going to see how the case guidelines or procedure is going to pan out.
I recall that in 2013, the first day of sitting, it was the petitioner, in this case Nana Addo Dankwa Akufo-Addo, who then was represented as the petitioner by his running mate at the time. Okay, again, we are seeing the arrival of some of the high-profile party members. Mr. Gabi Asari Ochridako making his way into the Supreme Court now. He's a very instrumental figure within the MPP and has very close ties with the president as well. And he has just made his arrival. But let's return to the issues again, Edward Nyakon. So I was talking about 2012, for example, and I've gone blank now. But
you're talking about the President Akufo-Addo as a petitioner.
Okay, so yes, the petitioner on the first day, represented by Dr. Mahmoud Bawumia. Yes, that was it. So the petitioners made a case. And then there were other follow-ups. Are we likely to see the petitioner today, whether himself, President Mahama, or a representative, make a case before we have the respondents come in at any point in time?
And these issues will be at the behest of the Chief Justice, because they are going to determine how the technicalities and then how the case is going to run out. So he's going to be the one that will roll out. Like I said earlier, if we're going to see about 9, we shall know later on, about an hour's time, we get to know those who are going to sit on the case. So if you realize that the last time we met last week, like I was trying to mention the names of the judges who sat on the case, we had a Chief Justice and Boa himself, Justice Sai, and then we have Justice Yawapau. We had also Justice Mariama Owusu, we had Justice Getu Tokonu, and then we had Justice Professor Niashi Kote also on the case, and Justice Nia Amagashi. So these were the 7 judges that sat on the case, and we are yet to know whether they are the very ones that are going to sit on this case, because we had some reports out there that some people indicating that if these were the judges that are going to sit on the case, we're going to hear some opposition from the NDC side, that they're going to protest against some of the judges that are sat on the case. So we don't know yet. Let's see how it goes.
And we have barely 30 minutes to the commencement of the proceedings itself. And you are a main factor in this coverage who will allow you now to find a comfortable place within the court to sit down, observe proceedings. Right after that, we will be speaking to some of the spokespersons on both sides, on the 3 sides, beg your pardon. And then we'll, by all means, come to you again to summarize for us how things may have panned out in court today. Thank you very much. And that was my colleague Edward Nyakon giving us a historical background, but also a peek into what is likely to happen in court today. Continue to be here with us throughout the day on GBC's channels as we continue to bring you up to speed, minutest details of the election petition 2020. Please don't go away.
And so we are live at the Supreme Court. We are also live here in studio at Kanda Broadcasting House. We will bring you details of what is going to transpire at the Supreme Court. Edward Nyakon and Abduhai Moment have been bringing you some perspectives. They've been taking you through what's actually resulted in the 2020 presidential election petition. And so on the 14th of January, that was the first time a hearing of this case started. It was an amendment by the petitioners, the NDC, led by His Excellency John Dramani Mahama, who says that at that particular point, there was an exchange. The first respondent became the second respondent. And so, I mean, there was a swap between EC and President Nana Akufo-Addo, who was the first respondent, and the second respondent there. And so today is Tuesday. The hearing of the case may be the substantive matter will commence. We are here together with George.
Yes, right.
And we'll be joined by Dr. Kweku Ajiman-Budu. He's a lawyer, law lecturer, head of law centers, Gimpa Faculty of Law, to bring you some other perspectives of this particular case, George.
All right, and we'll quickly move now to join Dr. Kweku Ajiman-Budu, who is a lawyer, he's a law lecturer, and the head of the law centers, Gimpa Faculty of Law. He's joined us via Zoom. We'll pick some thoughts from him on what to expect now that there's been that amendment and what the processes are going to be like today. When we get the signals clear from the Supreme Court, we'll take you over. They should be ready anytime soon. But quickly, let's move to Doc here. Doc, good morning to you.
Good morning. How are you doing?
I'm good. I hope you're well.
I'm doing well.
Okay, and thank you very much for joining us. Let's start off. Now that we've seen the amendments done, what's going to be next?
So, one of the things that the petitioner will be doing is moving a motion this morning to serve interrogatories on the first respondent, the Electoral Commission. And what it is that they will be asking certain questions, and interrogatories are simply written statements or questions that are served by one party on another party during proceedings or before we actually go into the proceedings. And this, we being in the pre-trial stage, that's one of the things that they are going to do this morning. Another thing too is that they are requesting that the first respondent admit certain facts so that they are determined for the purposes of the case. And some of the facts that they are hoping or requesting the first respondent to admit include whether or not there has been a practice of the first respondent, that's the Electoral Commission, in terms of the collation process from the regional to the strong room of the EC, and whether that was practiced in this past election, as well as other facts that they hope the respondent will admit for purposes of the smooth transition to the trial stage. So I think we're still in the pre-trial stage. So these are some of the things that we expect to see this morning.
With admission of those facts, about 30 of them, how significant are these 30 facts that the petitioner, that's the NDC of former President John Dramani Mahama, wants the EC to admit to the case?
You said how
significant is it to the entire process, the admission of these facts?
How significant? So they are facts that, upon reading them, there doesn't seem to be much dispute in terms of the things that they are asking the petitioner, the respondent, to admit. So, for instance, they ask, for instance, that on which date did Mrs. Jean Adukwei-Mensah, the chairperson of the first respondent, post a copy of the Form 13 at the head office of the first respondent. These are facts that are publicly available, and they just want to set it out so that we could move on to the trial proper. So I don't think, subject to whatever happens in court today, from my perspective or from where I am sitting, I don't think that there's any problem, if I may put it that way, or they are dispute, or they will be disputed. But obviously, we would have to wait to see whether or not these facts will be admitted by the first respondent for us to move on to the trial proper.
All right.
Right.
So a lot of these facts that the NDC wants the EC to admit to are contained in the main petition. Is it by way of process that an amendment be filed for the EC to admit this fact again before the main case proceeds? Because these facts are contained in the main petition.
Yes, so once they are moving this motion, for instance, or requesting the first respondent to admit the facts, if the court so desires, they would give the respondent or the first respondent time within which to admit to those facts that have been they've been requested to so admit. So it will depend. We need to understand that the Supreme Court regulates its procedure, and we know that the processes and the procedures for election petitions are contained in CI 16, which was subsequently amended by CI 74 and then CI 99. So the Supreme Court, and like I'm saying, we will have to see what happens in court today to actually appreciate what is going to happen. Because sometimes you may feel that these are pro forma things. Like you remember the day last week when the petitioner wanted the amendments. You remember that the respondents objected initially to the amendment, if my memory serves me right, but it was granted nonetheless. So these things happen. So we actually have to see how things play out once we get the feed and once we start with the pre-trial or the hearing.
Do you foresee this to be a very long? Is it going to be a long drawn process? I mean, the admission of facts today.
I can't tell. I mean, it's difficult to tell. Like I've been saying, we can't preempt what's going to happen today, because sometimes you may feel that things are straightforward, but you find out that they are not that straightforward, and all sorts of objections could be raised and things of that sort. So it's really difficult to tell, to give a timeline to exactly what's going to happen. But under the rules, the pretrial is supposed to be concluded, and then we can move on to the actual hearing. So depending on what the court decides, we would have a clearer picture of when the hearing will actually start and when witnesses will be called or witness statements will be filed and things of that sort.
But is it possible that the Electoral Commission will oppose this admission of facts that the NDC is calling for, or the former President Mahama is calling for?
I mean, it depends. If it's up to them and it's up to their lawyers to decide whether or not to oppose them, if they feel that there's a problem with it or not. So it really depends on them. It's difficult, like I'm saying, it's difficult sitting back, sitting behind to be able to peer into the minds of the Electoral Commission or their lawyers to know exactly what they will do. So some of these things, we need to let it play out before we're able to really know. Because like I'm saying, sometimes things may look straightforward or may seem straightforward, but in actual fact, they may not be straightforward. And so let's hold on and see. But sitting here, it's difficult for me to know whether or not the Electoral Commission or first respondents will simply admit the facts. The court has to even grant it in the first place for them to those facts. It's not as if you just bring the facts and that's it. You have to go through the process. So we'd have to wait and see.
All right. Let's take us through what the pre-trial is supposed to do before the trial itself, so that we can have an understanding of what exactly the pre-trial is supposed to do within this period.
Generally speaking, when you have pre-trial hearings, a number of things are done during the pre-trial hearing. So for instance, some of these things that we're going to be seeing today will be part of the pre-trial, the motion for interrogatories to be served on the first respondent, usually during the pre-trial, sometimes to the issues that will be set down for trial will be finally set out. So for instance, during the 2012 election petition, we realized that the issues that were set down for trial were whether or not there were irregularities, malpractices, blah, 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 and whether or not these were enough to affect the outcome of the results. So generally speaking, when we talk about pre-trials, they are our pre-trial hearings. They are hearings that are done, it's like the preparatory stage where the ground rules are set, where the issues for trial are set, where a number of administrative things that the parties need to follow are laid out so that everybody is clear in their minds what the process is going to be. So this, in a nutshell, these are some of the things that we expect during the pre-trial hearing as we're about to witness.
Right, Doc, so are there similarities between the 2020 petition and the 2012 petition? And so we want to look at duration. Are there any similarities between these two petitions, Doc?
No, I mean, during the 2012 petition, we realized that the whole hearing lasted for about 8 months or so. It started, the petition was filed in December 2012, and hearing began subsequently, and it took up to about 29th August, thereabout, of 2013, before a decision was finally given. And so, but when we look at our current situation, the fact that there's been amendments to the Supreme Court rules in respect of election petitions, presidential election petitions, we see clearly that now the court, or the Supreme Court, has 42 days within which to dispose of the petition. And this, many people have suggested, is an innovative way of dealing with the petition, because we know the impact that the 2012 election petition had on the country generally. The economy slowed down, investments slowed because people were not sure in terms of the stability of the country, because there was a situation where you had a candidate challenging the validity of the election of a president, and we know that the Supreme Court has the power to overturn an election results according to Article 64 and all that. So in that sense, there isn't that similarity, because the time frame within which the Supreme Court has to dispose of this case is shorter. So by the early parts of February 10th, February 11th, thereabouts, we would have gotten to the 42nd day that the petition will have to be disposed of. So in that sense, if we compare the rules that we have now to what we operated under during the 2012 petition that lasted up until August 2013, then we can say there isn't that similarity between the time frame within which a court has to dispose of the issue. But in terms of processes, even the processes may be different from that which we saw in the 2012 petition, because once again we know that the Supreme Court rules were amended, and for instance now joinder or applications are not entertained. We remember during the 2012 petition, the NDC as a political party applied to the court to join as a party or as a respondent to the petition, but under the current rules that we have, joinder applications are not entertained. So the only respondents are the person whose election, the validity of which is being challenged, and the Electoral Commission. And also the petitioner is the only person who is allowed to bring the petition. The one who says that he should have been validly elected, or that the validity of the election of the president is in question. So those are some of the differences that we can glean from the rules that we have governing the current petition and those that we witnessed during the 2012 election petition.
Right. So apart from that, what makes this particular case a unique one comparatively to 2012? The NDC's case primarily borders on total valid votes, declared. When you look at the petition, it doesn't really go down to polling stations and who signed and who didn't sign. Does that make this case a little bit different from the 2012 petition?
So if you look at the 2012 election petition, for instance, some of the reliefs that the petitioner was seeking, for instance, had to do with the presiding officers not signing the pink sheet, over voting, as well as voting without biometric verification and all that. And if you take the signing or non-signing of the pink sheets, for instance, the majority held that signing alone or the non-signing of the pink sheet alone should not invalidate the votes, because remember that people had gone to cast their votes, and so it will be a means of disenfranchising people if we just take the provision in the Constitution that mandates the presiding officer to actually sign the pink sheet before he proceeds to announce it. And so the majority were of the view that since no presiding officer had come out to challenge the validity of the results that were announced, or the petitioners were not necessarily questioning the validity of the results in question that the presiding officers did not sign. That constitutional prescription alone, if it is construed purposively, it will do injustice to the people if we allow votes to be invalidated simply because the petitioner did, the presiding officer did not sign that particular pink sheet. And so if you look at, and so that's just an example of one of the things that, or one of the main claims of the petitioner in the 2012 election, which was not accepted by the court. If you look at this current petition,
sure,
the respondent, or the second respondent, President Akufo-Addo, is essentially suggesting that to the extent that the petitioner is not questioning the validity of the votes in the 38,000 plus polling stations, as well as the special elections, 200 and something polling stations that we use for the special elections, that the petition is incompetent in the sense that it does not meet the threshold required for an election petition. So in simple terms, what the petitioner is suggesting, or what the petitioner is requesting the court, and if you look at the reliefs the petitioner is asking or praying the court for, the petitioner is suggesting or asking or praying the court along the lines of the mistakes that the electoral commissioner in the declaration of the results inadvertently made towards the declaration of the results. So they talk about the fact that she used different numbers in terms of the total valid votes cast to declare the results, and then subsequently in an unsigned press statement she purported to go ahead to correct the mistakes, and even in correcting the mistakes she made mistakes in there as well, and also she did not consult the political parties that were involved, especially the NDC, that they had written, loosely speaking, a petition to her to consider certain facts before she goes ahead to present the results. And so these are some of the things that they are asking for. And you notice that they are also asking for a second election between the petitioner and the second respondent, because according to them, on the basis of the results that the electoral commissioner herself declared, on the basis of the figures, no one obtained the more than 50% required to be validly declared as president-elect of the Republic of Ghana. So these are some of the things that shows you clearly, because in the 2012 petition, the petitioner was saying clearly that the petitioner was the one who was rather validly elected as opposed to the second respondent. But we have here the situation where the petitioner is saying that no one got or met the threshold of more than 50% of the total valid vote cast, which is the requirement under Article 633, I believe, of the 1992 Constitution, that leads to you being declared as the president-elect of the Republic of Ghana. So those are some of the differences between the two petitions.
Right. So one of the reliefs that the NDC is praying the court is an injunction restraining the second respondent, Nana Addo Dankwa Akufo-Addo, from holding himself as a president-elect. Now that he's been sworn in, this particular relief, what happens to it?
Nothing happens to it, because I mean it's moot in my opinion, because the Constitution, or the framers of our Constitution, realized that it was possible that the president could be elected and he could be challenged. The validity of this election could be challenged. And so they put in the Constitution Article 64, which gives certain categories of persons the right to challenge the validity of the election of the president. But they make it clear also that a declaration by the Supreme Court that a president was not validly elected is without prejudice to anything that that president would have done prior to that declaration being made by the Supreme Court. So what this means is that it is possible that the Supreme Court, upon the hearing of an election petition, can decide that indeed no one was validly elected as president and order a rerun, or the Supreme Court can decide that as a matter of fact, the supposed losing candidate was the one who was validly elected as president, and so they can make that declaration to that effect. But it will be without prejudice to anything that the president would have done. And what that means is that we can go ahead because Article 63(9), I believe, provides that a declaration under the hand of the Electoral Commissioner stating that the person was validly elected as president is prima facie evidence of the election of that person. And so we know that CI 135 was passed by the Electoral Commission, which was a declaration of president-elect instrument, which named Nana Addo Dankwa Akufo-Addo as the person validly elected as president of Ghana in the election that was held on 7 December 2020. But what it means is that, yes, that is prima facie evidence, and so that's why we saw the processes were followed, and on 7 January, he was duly sworn in as the president of the Republic of Ghana to begin his second term. But that does not take away the fact that a petitioner can challenge the validity of the election, and the Supreme Court can declare that indeed the validity of the election of the president is in question, or he was not validly elected, and can give whatever orders it deems fit that will ensure justice in that particular situation.
Okay, that's
without this.
Look, we'll have to just come in here and end this at this particular time. We'll quickly move to the Supreme Court and pick proceedings from there. If and when we have enough time, we'll come back to the studio. So also join our colleagues there at the Supreme Court. So we will be taking you now over to the Supreme Court for the hearing of the 2020 election petition.
And Abdul Hai Moment and Edward Nyako are on the ground,
yes,
so they can continue the discussions, from the ground.
Respectfully, my lords, writ number J1/5/2021, John Dramani Mahama versus Electoral Commission, Nana Addo Dankwa Akufo-Addo. Respectfully, my lords, petitioner present. Electoral Commission. Your name and position, please. Your name? Jane Mensah. Jane Mensah, chairperson, representing the first respondent, Nana Addo Dankwa Akufo-Addo. Please, kindly speak up. Peter McManu, my lords, is representing the second respondent.
Please, may I have your attention? Please, we are sorry we were a bit late because, as you are aware, some processes were filed late in the night, and late in the day yesterday, but we were unable to receive some of them. So in the morning, we had to take some few minutes to go through. So bear with us. Thank you.
Please, your lordships, I fear with me my learned friend Tony Lisa.
Thank you.
Yes, for the petitioner.
For the petitioner.
If it pleases the court, Justin Amenuvo appears with A.A. Somoa Samoa for the first respondent.
If it pleases your lordships, I appear for the second respondent. My name is Akoto Ampao. My lords, with me are my learned colleagues, Mr. Frank Davis, Mr. Kweku Eserfi, and Mr. Yao Opong.
Yes, Mr. Chikata, please, we notice that there are about 3 interlocutory applications which have been filed. The nature of the application is that we can't consolidate them, so we will put you to your election to pick the one you want to argue first.
My Lord, respectfully, we have a request to admit facts. That is not at this stage an application before you. It's a request that we have filed to the first respondent
yes,
to admit certain facts. Yeah. So that is, strictly speaking,
not a motion.
That is correct.
But we could see application for interrogatories.
Yes, the application for interrogatories is actually the only application that is before your lordship this morning.
Okay. So.
As I respectfully move in terms of the motion paper and the supporting affidavit, we're seeking your leave to serve interrogatories as exhibited, Exhibit A, on the first respondent.
Yeah, Mr. Chikata, under which rules of the Supreme Court jurisdiction in election petition are you invoking our jurisdiction?
Lord, it is the combined effect of CI 16 Rule 5 and CI 47 CI 47 order 22, Rule 11. My Lord, evidently CI 47 is the High Court rules. I'm well aware of that. But your lordships have ruled in the election petition of 2012 and 2013, which is reported in a special edition of the Supreme Court of Ghana Reports 2013. Your lordships have made it quite clear that your lordships apply CI 47 where there is no express rule that is in the Supreme Court rules themselves. And I don't know whether your lordships want me to go through that authority. It is fairly well known. So your lordships ruling in respect of the matter of interrogatories is to be found from page 50 of that special edition, and it was a ruling delivered on behalf of the court by Justice Badegbe. And the part where he refers to CI 47 is at page 54. Where he says, it does appear to us that the framers of the rules of this court envisaged a gap in the rules regulating the practice and procedure in the Supreme Court by making a provision to that effect in Rule 5 of the Supreme Court Rules 1996, CI 16. In this regard, we think that the current High Court Civil Procedure Rules 2004, CI 47, particularly Rule 12.6 of Order 11 on application for further and better particulars and Order 22 on interrogatories are beneficial to us by way of guidance as to the appropriate practice to prescribe in the course of the exercise of the original jurisdiction of the Supreme Court. It is Rule, it's Order 22, Rule 1, that is expressly referred to in that decision. It is to that order, it is to that order that we make reference when I stated that we're coming under Rule 5 and Order 22 of CI 47. And my Lord, that statement of His Lordship Justice Badegbe is further reinforced by the provision in Article 1284 of the Constitution of the Republic of Ghana.
Your chair is regulating your movement behind it here.
And Article 1284 provides that for the purposes of hearing and determining a matter within its jurisdiction and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So the Constitution makes it explicit that your lordships have the power that is vested in every other court. I'm sorry, 1294. 1294. 1294. I read it right, but I didn't. 1294. Yes. And my lords, the clear purpose of discovery under CI 47, the clear purpose yes, of discovery. Interrogatories are part of the process of discovery.
In that sense, okay.
And I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court. And my lords, all the proposed interrogatories, and there are 12 of them, in our respectful submission, are designed precisely to narrow down the issues for trial. Your lordships will, if I may respectfully refer to Order 22, Rule 1, from where your lordships will see, which is headed Discovery by Interrogatories. And Rule 1.1, a party may apply for an order giving the party leave to serve on another party interrogatories relating to any matter in question between the applicant and that other party in the cause or matter, and B, requesting that other party to answer the interrogatories on affidavit within such period as may be specified in the order. Rule 1.2 then makes reference to Form 10 in the schedule, and Form 11 is the answer that will be provided. We have complied with the Form 10 in the schedule in indicating what we are asking for leave to serve by way of interrogatories. And your lordships will observe that starting from number 1 in the interrogatories, where, before I get into the specifics, there is another passage in the judgment of Justice Badegbe that I wanted to refer to, and I would respectfully ask your leave to do that before I go into the specifics. And this is a passage from page 59 to page 60 of the judgment. And his lordship says as follows: this leaves us with the application of the petitioners for interrogatories directed at the second respondent electoral commission. The application has been resisted on the ground that it has the effect of allowing the requesting party, the petitioners, to fish for information. If the said contention is correct, then the application must fail. We have carefully considered the application, and we are of the view that the request does not come within the designation of the word fishing as pronounced by Greer Lord Justice in the case of Rofe and Kevorkian, wherein he observed. And then he quotes that. And his lordship, after quoting from that English authority, says, we have carefully examined the application relating to the request of the petitioners and are satisfied that they are within the scope of permissible interrogatory. So in that particular instance, the lordships allowed the interrogatories to be served on the second petitioner. And that is what we are seeking for your lordships to do in this case. In the specific interrogatories, we have questions regarding, in number 1, the practice in previous presidential elections involving collated figures from constituencies being received in the strong room in the presence of agents, and the further question whether that practice was followed, and the third question whether the 7th December presidential election was the first time regional collation centers have been interposed between constituency collation centers and the headquarters of the first respondent. My Lord, respectfully, these are matters which, in the answer of the first respondent, in paragraph 5 of the answer particularly, the first respondent sets out a procedure that the first respondent says is the procedure as detailed below. So, my Lord, these questions about the regional collation centers are directly related to what the first respondent sets out in paragraph 5. And equally, the questions the question in question 4, how the results were transmitted from the constituency collation center to the regional collation center, that is clearly a question that arises from the process that is described, and that is clearly relevant. Yes.
Question 4. Should I understand it to mean the mode of transmission of the result? Is that what you are referring to?
That is correct. Okay. That is correct. And related to that, we also have in 6 a very specific question. Did the National Communication Authority facilitate in any way the transmission of results to the headquarters of first respondent? Again, that's a very specific question as regards whether the National Communication Authority facilitated in any way the transmission of results to the headquarters of first respondent. My Lord, respectfully, I mean, the issue of the mode of transmission is very important, especially for determining the authenticity of what was transmitted. And so it is very much at the heart of what is before your lordships in this petition. And whether the National Communication Authority facilitated is again capable of a very simple answer: yes or no. And in question 7, the interrogatory seeks to find out, when did Mrs. Jean Adukwe Mensah, is it Adukwe or Adukwe? Adukwe, yes. When did Mrs. Jean Adukwe Mensah, the chairperson of first respondent and the returning officer for the presidential election, first realized there were errors in figures she had announced in her declaration of 9 December 2020? When? This is a question only one person in the world can answer.
Mr. Chikata, why wouldn't you limit?
I'm sorry?
Why wouldn't you limit your references to the EC to the office, the chairperson, rather than the personality? It seems to me that your attack is against the personality of the person and not the office. So we'll be happy if you just limit it to the chairperson of the EC, because in her absence, any of the deputies, anybody at all could step in.
Respectfully, my lords, there is only one returning officer for the presidential elections.
And that is
that returning officer is not the EC. That returning officer is the chairperson of the Electoral Commission.
At that, chairperson, that's all. We are not interested.
The chairperson has a name. I'm not able to mention the name of the chairperson. No, my Lord, respectfully, I want to understand. Am I being prohibited from mentioning the name of the chairperson? Is that the issue?
Reading through your petition,
yes,
as to the instant application, the constant emphasis on the name. What I'm telling you is that we'll be satisfied just with the designation, because in her absence, any of the deputies could act in that position.
My Lord.
So if it is an election petition, and you are challenging the election of the president, it is sufficient that the institution charged with the responsibility of conducting that election had done their work, and the chairperson, who is the head, represents that institution, and not the personality, the name.
My lords, with the greatest respect, I believe that the constitutional requirements regarding the returning officer and the particular circumstances that we are dealing with in this case do not make it possible to have the situation that you are envisaging, where somebody else steps in for the chairperson. Respectfully, the Constitution makes the chairperson and only that chairperson the returning officer. And in the circumstances of this case, that chairperson happened to be the person that we refer to in the petition. And that chairperson actually was the person who undertook her responsibilities in accordance with the various constitutional and legal provisions that we have. So, my Lord, we do not mention her name by way of targeting an individual. That is very far from it. My Lord, when I cited before you a decision of the Supreme Court, and I cited the decision of Justice Badegbe as an individual judge, he read a unanimous decision of the whole court. I did not target Mr. Justice Badegbe when I mentioned his name, because he happened to read that judgment, which was a unanimous decision of the court. And equally, I do not target Mrs. Jean Adukwe-Mensah when I say that she made the declaration on the 9th of December. It's not a targeting, it's just a fact that is material in this particular petition.
So thank you. You may continue with your submission.
And that is why in the next interrogatory 8, the question is again posed: how did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent and the returning officer for the presidential election, get to realize there were errors in figures she had announced in her declaration? And respectfully, my lords, as I said in respect of question 7, there is only one person who can testify to those matters. And question 9, in respect of the purported corrections, and we put corrections in quotations because, I mean, whether there were corrections or not is itself an issue. In respect of the purported correction made to the figures in the declaration by the first respondent, was there any prior process of conferring with agents of the presidential candidates? And then 10, did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent, present Form 13, the Declaration of Presidential Result Form, to all the agents of the presidential candidates to sign? And if so, did all of the agents sign? 11 is on which date did Mrs. Jean Adukwe-Mensah?
Mr. Jikata, Adukwe in Ghana is a male. The female is Adukwe. She's not Adukwe.
I can only bow to the superior local knowledge of your lordship. So Adukwe, I'm most grateful. My friends could not help me, but I'm grateful. I'm grateful to your lordship. Adukwe. And we seek to ask whether, that is 10, did Mrs. Jean Adukwe-Mensah, the chairperson of the First Responder, present Form 13, the Declaration of Presidential Result Form, to all the agents of the presidential candidates to sign? And if so, did all of the agents sign? And 11, on which date did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent, post a copy of the Form 13 at the head office of the First Respondent? And 12, did the First Respondent record any discrepancies which were occasioned by computational and mathematical errors in the cause of the collation of the results. So each of these questions, which is capable of a relatively simple answer, we believe will narrow down the issues that are before this court. Your Lordships will be aware that Regulation 44 of the Public Election Regulations sets out, particularly 4410, it sets out what the chairman of the commission, the CI 127 assumes that it will be a chairman, but the chairman of the commission it sets out exactly what is done in connection with the process. And the interrogatories that we are filing will, by clarifying these matters, will narrow down the scope of the inquiry before your Lordships. We have this morning been served with an affidavit in opposition by the first respondent. And I would simply say to your Lordships in this context that nothing in that affidavit in opposition provides a justification for us not being granted leave. My lords, in paragraph 4, following paragraph 3, in which the first respondent, which the affidavit is sworn to by Mrs. Jean Adukwe Mensah. And in paragraph 4, she says, I object to answer to paragraphs 1 to 3 as irrelevant as the steps taken by the first respondent is in accordance with the Public Election Regulations CI 127. My lords, with the greatest respect, whether they are in accordance or not in accordance is an issue before this court. Whether what has been done by her is in accordance with the Public Election Regulation is precisely an issue before this court. And that issue is not going to be determined by a paragraph in her affidavit. Indeed, my lords, the logic of the questions 1 to 3 should be obvious on the face of those questions. Questions 1 to 3 start from the practice before 2, whether, and 3, whether the first time regional collation centers have been interposed between constituency collation centers and the headquarters of first respondent is in the 7th December 2020 election. So, my Lord, there can be no basis for saying that these questions are irrelevant to determine what actually happened, which is what this case is about. And in paragraph 5, she proceeds to object to answer 4, 5, 6, 7, and 8. Now, my Lord, 4 is how were results transmitted from the constituency collation center to the regional collation centers. My Lord, I mean, this question can hardly be irrelevant to this petition, because this question about how results were transmitted is critical for the determination of the authenticity that she's claiming for the results that she declared.
Mr. Chikata, could you kindly point to the paragraph of your petition that this question is related to?
The paragraph that is related to is the paragraph of the first respondent's petition, as I indicated earlier. Answer.
Which paragraph?
The first respondent.
Which paragraph?
Paragraph 5, I referred to earlier. Paragraph 5, where she sets out, where the first respondent, not she this time, the first respondent, Electoral Commission, sets out the 4-stage procedure.
Thank you very much. Thank you very much.
And so my submission, the question how this collation was transmitted, or how the results from the collation center at the constituency were transmitted to the regional collation center, and how the results transmitted from regional collation were transmitted to the headquarters. Those questions 4 and 5 are clearly critical to what was actually done in this election, not just what is required to be done in general terms, but what was actually done. And, Lords, we cannot see how questions 6, 7, and 8 can be described as irrelevant either. And my Lords, in paragraph 6, with respect, what the deponent seeks to do there is to anticipate your Lordship's granting us leave, because she's giving an answer to that question. And respectfully, we would like her to wait until you have given us leave to serve her, and then we can read her answer at that point. She is anticipating it in paragraph 6, and we are grateful for that anticipation, but that should await Your Lordship's grant of leave and the service on her, the service on the first respondent of the interrogatories. My lords, there are other responses in the remaining paragraphs. I only comment on the one suggestion that we are unnecessarily attempting to delay the trial. Nothing could be farther from the truth. And we actually take exception to that suggestion and that averment in the affidavit. We take strong exception, in fact, I may say, to that suggestion that we are attempting. The purpose of discovery, as I've indicated, is to limit the matters for trial. And if only she would just stick to answering those interrogatories, I think the processes of this trial would be expedited rather than to make facetious statements about our intentions. We are therefore respectfully asking that your Lordships grant us leave, and I believe that upon these interrogatories being filed, they can accelerate the processes for responses from the first respondent and therefore for the further processes of this trial. That is all.
Yes, my lords. My lords, we are opposed to this application. Lords, we rely on all the depositions in our affidavit in all. Lords, the answer to the question are in the petitioner's own petition. The answer filed by the first respondent, also the filed by the second respondent. Hello. Regulation 44.9 of CI 27 sets out how the first respondent will declare results, and in it, questions being asked of us. Where did the regulation pop up from? It's all in the law. That is saying that it's in the law before this court. And those are the steps that the first respondent followed. My lords,
session of the
my lords, right. Regulation 44 sub 9. Regional collation officer shall, upon receipt of the presidential election collation as set out in Form 9 and the presidential election results summary sheet as set out in Form 10 of the schedule from the district electoral officer in the presence of the public and with not more than 2 counting agents appointed by the parties contesting or the polling agents of the party the presidential results from the constituencies as set out in Form of the schedule. Fill the presidential regional results form as set out in Form 11 of the schedule. Presidential regional results summary sheet as set out in Form 12 of the schedule. Request the so my lords, it is all set. It's where what is done at the regional level. My lords, we said in our answer that indeed had signed 13 of those. We have also stated in our answer that where a party fails or refuses to sign on any of the forms at this stage of the process goes on. Just a second.
That you are submitting before the court that your responsibility is stated in the law, as you rightly stated here. So, can you? I know, depending on the ruling of this court, you may have to answer or. But
my lord, regarding you are asking about question 4 and 5. Yes, because as we have stated, I think somewhere in the answer, it's transmitted by fax. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court. My lords, I wish to refer your lordships to the case of Nana Addo Dankwa Akufo-Addo versus John Dramani Mahama and the EC. Lords, is reported at page 61 of the special edition of the Supreme Court of Ghana Law Reports. My lords, I would draw the court's attention to page 71, and with your kind permission, let me read what the Supreme Court, speaking to Adina JSC, said. In the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which has enabled them to mount this petition on grounds of malpractices in 4,709 polling stations based on the contents of these duplicate documents in their possession. The affidavit in support of the application does not disclose any need for the inspection and making photocopies of original documents. Lord, I wish the court to apply this decision and hold that the matters for which the petitioner seeks interrogatories are well within his domain, and he was well armed with those before he filed the petition in this matter, and therefore he is bound by his pleadings in the petition, and therefore cannot come through the back door and seek further information through these means. Lords, I would also wish to refer your lordships to the Metonunu case, Lords. Lords, it is Metonunu and others versus the Electoral Commission, 2007 to 2008, Supreme Court of Ghana Law Reports, 1250. Lords, I wish to draw the court's attention, with your kind permission, to the obiter dictum of Dateban JSC. It says, it should be noted in particular that Article 49.3 requires the announcement of the voting at the polling stations before they are communicated to the polling officer. Such announcement has the effect of the results in the public domain. Observance of Article 47 means, in effect, that Independent Commission publishes at each polling station the results from that station. We do not therefore see the need to as a condition of the validity of the declaration of the election of the president-elect, the added publication obligation that the plaintiffs have argued in this case. If the election system operated by the defendant could not function without such a publication, we could have been persuaded to imply such a publication in order to make the system workable. So, my lords, the point we are making is that there are 8,000 polling stations countrywide. Petitioner are appointed agents in each polling station. The results were forms filled, his agent refused to sign, he moved on to the constituency, he had agents there, they signed, if they refused to sign, he moved on to, and so on, and then the
for interrogatories, which is before us. So this is being used as precedent.
No.
So what do you say? Because counsel is entitled to rely on precedent and invite the court to follow precedent already set out.
My lords, distinguishable precedent. My lords, with respect, the 2013 situation is different. And mind you, my lords, interrogatories, grant or refusal, is discretionary. And it has to be based on the set of facts at every situation. It doesn't arise in this case. It doesn't. And that is why I said, yes, there is precedent, but precedent is distinguishable based on the facts and the processes that are before you in the pleadings, my lords.
So why are you saying that in this particular case it is not applicable? In
my
this
lord,
particular petition, why are you saying it is not applicable?
Because the answer he seeks are all in the document before the court. And then the law that they themselves have relied on, which we also rely on, they are there. I just read to you the steps. You are asking me that when did the original issue come up, etc. If you read the law, you will see that it is in there.
Thank you.
Thank you very much, my lords.
My lords, I pray that I be permitted to make a few observations of law.
Are you making observations or you should be permitted to respond?
Submissions.
I think the application is basically directed at the first respondent. Because you will not be compelled to answer any question. Yes. If I understood counsel for the petitioner, yes, you are not under any obligation whatsoever to answer any of the questions serialized in the document annexed to the affidavit.
Yes, my lord, and it is true that no specific interrogatory has been directed to second respondent. However, we are an interested party in this matter, and if we can assist the court on legal issues, we think we should be permitted to do so.
Yeah, Mr. Akutampa, if, as you rightly said, if it's a legal issue, if it's a question of law, we can hear you, because seriously you did not file any affidavit in position with regard to the facts.
Yes. That is what.
So, as a party in the petition and an interested party, if there's any legal point you want to address for the benefit of the court and all the parties, I think you can do so. Go.
My lord, very briefly, my lord, I think the first point to make is that interrogatories must relate to matters in contention between the parties. And that is clearly set out, my lords, in Order 22, Rule 1A, Rule 1, Sub 1A. It reads, with your permission, a party may apply for an order, A, giving the party leave to serve on another party interrogatories relating to any matter in question between the parties. My lord, and it is further reaffirmed by 6A of the same rule, which states a proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC. Furthermore, my lords, it is our case that if your lordships consider the questions as to NCA, there's nothing in the petitioner's case that raises that matter as an issue. Very, very well. So my lords, that
allowed to make some raise points of law to assist the court.
Yes, my lord.
You are
now,
taking us
finally.
Yes.
The final point I want to make
yes.
is that counsel for the petitioner referred to Badagbe JSC statement in the earlier presidential petition, but he did not quote Grill LJ, because what Grill LJ said is significant. And my lords, with your permission, I'll read from here. It is, however, the nature of fishing interrogatory trying to get, for the purpose of the defendant's case, evidence which he has not already got. On these grounds, having regard to what has frequently been decided, that because any question is a proper question to put in cross-examination, it is not therefore necessarily a proper question to put in interrogatories. We have decided that interrogatory 3 also ought to be disallowed as being a fishing interrogatory. And my lords, it is our submission that these interrogatories are indeed fishing interrogatories and should be disallowed.
May I, with your leave, just address a couple of points? My Lord, I would respectfully first observe that counsel for the first respondent, in effect, admits the relevance of these interrogatories, because he claims that they are dealt with in their answer. So there can't be any doubt that they are relevant. And the question whether they are in fact dealt with in the answer is the question that your lordships are going to have to decide. But he said that those matters in the interrogatories are dealt with in the answer. Now, my Lord, the second point I respectfully make is that he said that everything is in the law, and those are the steps that the EC is supposed to follow. We know that. We know what is in the law. But the interrogatories are designed to elicit what actually took place in order for your lordships to determine whether they were in accordance with the law or not. So you can't just keep telling us that everything is there in the law, everything is there in the law. We know that. But we have to establish a certain factual basis on which...
My Lord, with respect, is my learned friend re-arguing?
No, this is not re-arguing a point. He is responding to the issues you raised when you quoted the
Yes, but my Lord, it will have to be on points of law, as is the tradition in the courts.
Counsel,
yes, my Lord.
Let him proceed.
And my Lord, learned counsel also referred to what Justice Adingra said. And I believe he quoted from page 71. My Lord, I respectfully draw your Lordship's attention to the fact that the decision of Justice Adingra was in respect of an application for further and better particulars. It was not the interrogatories. The interrogatories were dealt with in the decision of Justice Badegbe. And in her decision, in respect of the application for further and better particulars, her ladyship actually makes it clear she makes it quite clear that her decision is tied to the fact that there are other applications pending, including the application for the interrogatories. And basically what her ladyship was saying in the passage which I'm about to refer to is that those other applications are sufficient to take care of the matter which is being there. So that decision, which is about further and better particulars, respectfully cannot, it cannot be a basis for the submissions made. And as regards the reference to an obiter dictum of Justice Dateba, the less said about obiter dicta in this particular case, the better. I respectfully submit that far from us coming through any back door, we are actually coming through the front door of the Electoral Commission based on their own answers in order to ascertain the facts on the basis of which this court can reach a just determination.
Yes, for my edification, question 6. Question 6.
Yes, my Lord.
How does it relate to the pleadings so far filed before this court?
My Lord, counsel actually claimed that they talked about faxing. Now, all these communication systems, phones, faxes, fall within the authority of the National Communication Authority. And therefore, my Lord, therefore, a question as regards whether there was any facilitation by the national communication, my Lord, I need hardly acknowledge that, I mean, the security of, communications in terms of an election process, all those matters are clearly important in the context that your lordships are faced with. So the question whether the National Communication Authority, as the institution that is legally mandated to have responsibility for communications facilities in the country by law, whether they facilitated in any way the transmission of results, my Lord, is an appropriate question. Respectfully.
Mr. Chikata, this is not one of the grounds which you have stated in your petition for invoking our jurisdiction. Look at your petition. It's not one of the grounds. The mode of transmission of the results is not one of the grounds.
My lords, with the greatest respect, the mode of transmission cannot be a ground for a petition like this. The mode of transmission cannot be a ground. The mode of transmission becomes relevant in an adjudication related to what the first respondent is claiming was done. The first respondent has filed an answer and makes certain claims. Now, my Lord, those claims don't need to appear in our petition to be relevant. Those claims are the claims that are put in answer, and therefore issue is joined in respect of those claims that have been made in the answer. So the question that we are raising about the mode of transmission is critical, because it is a question that enables this honorable court to determine the authenticity of whatever transmission took place. That question is extremely relevant. And I believe learned counsel for the second respondent claimed that it can be asked in cross-examination and so on and so forth. But we don't need to wait for cross-examination. The purpose of dealing with it at this stage is to avoid having to go through lengthy cross-examination.
Thank you. Thank you.
The court will take a very short adjournment and come back to deliver the ruling.
All rise.
So the court has just taken a break to, I believe, to take a decision on what has been happening since morning. What happened is that the lawyer for the petitioner, led by Mr. Chachu Chikata, filed a motion to ask the EC chair to admit that she indeed made errors in the declaration of the election petition results. Of course, lawyers for the first respondents, the EC, opposed that interrogatory injunction, and so did the lawyers for the second respondent as well. The court is currently on recess, and when they return, we are sure a decision will be made on this matter. But my colleagues who have been in court, Barbara Kuma and Edward Nyako, you have been following proceedings from within the court itself. Can you summarize exactly what has been happening within the court since morning?
So basically what happened today from 10 a.m., the court started at 10 a.m. exactly. And then, earlier, yesterday, the petitioners, that's the former President John Mahama, petitioned the court or filed an application for some questions to be answered by the EC. And so that's what they sat on today. And the court is yet, the court has risen and is yet to decide on what they should do, as to whether to grant it or to refuse it, as the EC lawyer has opposed, or whether to grant it as the petitioner has sought. So
yes, exactly. We also noticed that there were a lot of back and forth arguments between the lawyers for both, in fact, for all three sides. After Mr. Chachu Chikata laid the motion, the EC lawyer, Mr. Amenuvo, of course, rejected that motion, and so did Mr. Akoto Ampao, who is a lawyer for the second respondent as well. What were their arguments all about?
Yes, basically, I think Mr. Chachikata raised some issues at interrogation. He's calling for interrogation, that is interrogatory injunction, and they were 12 in number. And apparently one of them that he was seeking for is a mode of transmission. He was asking whether the NCA contributed to the transmission of the results, and was it how it was even was done in 2012, the regional coalition system that was instituted. They are questioning all these things, and his argument is that it is through these that it will be able to elicit the information is required. And the EC council is saying that he's coming to the back door to bring extra issues that were not, captured in his petition, which Mr. Chikata also said that it is through what he's doing that will enable. So he thinks that he came to the front door. It is through that will enable him to get these questions answered. And so to the EC lawyer, it is irrelevant because all that he did was within the remit of the law, and he cited the relevant laws to buttress his argument. And then came in lawyer Kotompa, who was told by some judges on the panel that the issue at stake does not concern him. But so he wanted to raise a submission in terms of legalities, and therefore he quoted some sections of the law to buttress what he's also saying. So, after listening to the three sides, one way or the other, the judges of the Supreme Court have risen and they've gone to their chambers, and we're expecting them to come back and give us the decision. Because
but I also realized that in making their cases, all lawyers quoted from events from the past. And so Mr. Chachu Chikata, for example, quoted copiously from Justice Badegbe's judgment regarding a similar case in the past. There were also instances where reference was made to the fact that even in the 2012 election petition, which happened in 2013, that there was a point in time when the petitioner asked for interrogatory injunction, which was granted, and so on. Again, for the layperson watching us, how would you be able to explain this to their very minimal understanding?
Well, what I deduce, my little knowledge in law, shows that he is asking for this. But let's not also forget that the EC lawyer also pointed out Mr. Chikata was not looking at the whole issue, and he talked about the fact that the facts are different from what happened in 2012 this contexts are different. And so that's one of the arguments he was making. So essentially, what I understand is that there are some questions the petitioner wants to pose to the EC, and he's asking the court to grant him the right to do so. And the counsel for the EC is resisting that everything that is asking is already captured in the response to the petition.
Again, Barbara, you have been covering events in court for a long time now. When there is time for cross-examination, does that not present lawyers the opportunity to ask these questions? The kind of question that lawyer Chachuchi Kata, for example, is asking to be allowed to ask. Couldn't he have just asked that if Madam Jane Mensah, for example, were to come to the witness box?
Yes, definitely it does. During cross-examination, it does afford lawyers or counsels to ask these questions. But if you realized in court today, when a similar question was posed to Mr. Chikata about why he wouldn't wait until maybe cross-session so he could answer cross-examination so he could question the EC or whoever the relevant person is to answer that question, he said that, I mean, what they were trying to do as of today, what they are seeking for today is to minimize or narrow down the petition or the scope of whatever will be done at the Supreme Court during the hearing. So that was why they came to court to seek specific questions to be answered by the EC so that during the actual trial, these questions don't come up again.
Indeed, he did make that point. Mr. Chachu did make that point that they are seeking to actually minimize the number of hours that will be used during cross-examination and so on. But of course, you also heard him refer to the fact that they take great exception to suggestions that they are using certain technicalities and tactics in order to delay the entire process. I mean, there's a back and forth argument since we've been having this morning, haven't we?
Yeah, exactly. That is what the law is all about. It's about knowing what relevant laws to quote to buttress your argument out there. Let's not also forget that the EC lawyer consistently indicated that all that they are requesting for has been captured in their response, and therefore there's no need for them to be, to be asked to respond to these things. So, to them, what they have done is within the remit of the law. And secondly, he also talked about the fact that all the agents of the various parties at the constituency level, district, at the regional level, signed, and the various parties as well. And so to them, that is what the law asked them to do. That's I was quoting the CI 147 or so. That is what's asking them to do. So they have done the relevant. They've done what is within the remit of the law, and therefore they could not be asked again to come and answer. So these are some of the issues that. And then one of the judges, I remember, I've forgotten his name, but he's talked about the fact that the mode of transmission would help in the mode of transmission. He also questioned it, and Mr. Chikata insisted that. And that is why they're doing that, because they want to know who supported or helped in the transmission of these results. So that is the argument that was put forward. So we're waiting for our laws.
Yes, and even as we wrap up this very short conversation, again, Barbara, you've been reporting from court for a long time. When such situations do arise, usually when the jury goes into chambers, how long does it take them to arrive at a decision to come out and then continue with the rest of the case?
That actually depends on the application being sought or the complexity of what the application is about. It can take them a while. It can also take them a very short time. It can take them a longer time to arrive at the decision, and then later on come and then tell us what they.
I'm asking this question again because, Edward, you recall that on Thursday, the first sitting, when the court had to decide whether or not to allow the petitioner to amend the petition, it took a very short time for that decision to be arrived at. Looking again at the fact that the Supreme Court itself has given itself a certain deadline, you think that these matters, which are really not the substantive matters that we are here for, will be handled within the shortest possible time?
Yeah, that's what the law is about. Each and every case has its own, merit that you have to look at. So I believe that the judges of the Supreme Court know what to do. So they've gone to chamber. You know, in our tradition, we say that so they've gone there to see the old lady, and I think they're going to put their heads together, as we say, so one head cannot take a decision. They've gone now into their chambers and will come back and tell us exactly. So we don't know how long, but certainly because we have deadline, they would deal with this matter as soon as possible.
All right, thank you very much. My colleagues Edward Nyako and Barbara Kuma will return to the premises of the court, and we'll continue with our coverage. Please don't go away. This is where to get all the minutest details in respect of election petition 2020.
seem not to, we've lost him there. We're talking to Dr. Kweku Agyemang-Budu, who is a lawyer. He's also a law lecturer and the head of Law Center's Gimpa Faculty of Law. He joined us for us to explain one or two things that have been going on so far at the Supreme Court. Morris is standing by. We'll go through some of these questions that the petitioner is really seeking to ask the first respondent, which is the Electoral Commission. And for that reason, the court is on recess now to determine whether that should be granted or not. Morris, let's go through some of these questions. Yeah.
So I think that the first one would they want to confirm from the EC chairperson that the purported declaration of the presidential election result of 7th December 2020 by Mrs. Jane Mensah, the chairperson of the first respondent on 9th December 2020, was broadcast live on radio, television, and other electronic media. They want to, confirm and state this on fact. They also say that Exhibit A attached to the petition hearing is a video and audio recording of the purported declaration in respect of the presidential election results of 7th December 2020 made by Mrs. Jane Adukoy Mensah, the chairperson of first respondent, which is the EC, on 9th December 2020. They also want to, put this as a matter of record. Okay, right. That Mrs.
Oh, just hold on for me. Right. We have Doc back on the line. So let's just go to the telephone to talk to Dr. Kweku Agyemang-Budu, who is a lawyer and also a law lecturer and the head of Law Center's Gimpa Faculty of Law. Doc, thank you very much. We lost you earlier. My question was, there was this other argument that these questions that the petitioner seek to ask the first respondent can be addressed during cross-examination. Hello, Doc. Doc, are you there? Dr. Agyemang-Budu. Okay, we'll work on that line again and see how best we can get him back on the line. So we're talking earlier about some of the questions that are raised by the first petitioner to the respondent to ensure that they address some of these issues, seeking to clarify one or two things. And according to the first, the petitioner, these are issues of fact they want to rectify, if I would say, and also allow the first respondents to also admit them. And subsequently, other things will follow. But the court, after listening to arguments from the petitioner, the first respondent, and the second respondent, although that injunction was not really related to them, but had to really raise an issue of law there, and legal issues there, which it was granted to do. And subsequently, the court is in recess to decide whether or not the petitioner will be allowed to ask those questions, and whether or not the first respondent will be allowed to answer those questions. Let me move back to Morris there. Yes, Morris, you can continue.
Right, so we also want to put on record that Mrs. Jane Adukoy Mensah, the chairperson of the first respondent, has made no other purported declaration in respect of the presidential election of 7th December 2020. Judge,
right.
I think you want to go
We're
back
doing
to
this
that.
a lot, so let's go back to Doc now. Doc, can you hear me now?
Yes, I can hear you.
All right, thank you very much. My question before the line dropped was this other issue that these questions that the petitioner seek for the first respondent to answer can be addressed during cross-examination. Yes. What about the relevance of that bit of it?
I mean, that's what I believe it was the respondent that was making that suggestion, and the petitioner or the counsel for the petitioner was suggesting that why don't we get it over and done with at this stage so that we expedite the proceedings, if you may. And so it's up to the court to make that determination. Like I said, we don't want to preempt anything that is going to be done by the court. That wouldn't be the proper thing to do. So we would have to wait to hear the ruling of the court when they come back. And I believe that since they suggested it was going to be a short recess, they will be back in time soon. So that determination will be made, and we'll see what they decide at that point. But we shouldn't be speculating at this point in terms of what they are going to do or how they're going to deal with the issue at hand. I hope you understand me.
I do. And with they going into recess now, how long does it take for them to finally come out with a decision?
I wouldn't know. They said it was going to be a short recess, so it's difficult for me sitting here to know how long you're going to take. It depends on the deliberation that you're going to have and how deep-seated the issues involved are. And so the Honorable Chief Justice, I believe, suggested that it was going to be a short recess. So I guess in due time, we would have them come back and there will be a ruling on the matter. But I can't sit here and tell you that it's going to take 10 more minutes or 15 more minutes or anything of that sort. That would be disingenuous and that will not be proper.
Okay. So that means that after the ruling, we're still within the pre-trial, or the trial itself can begin?
No, I mean, we're still within the pre-trial. Like I said earlier on, once the pre-trial hearing, according to the rules, once the pre-trial hearings are done, then we can move on to the next stage, which is the hearing of the substantive matter. So you can tell that.
Okay, I think we've lost Doctor on the line. We'll get back to him. Let's move back to Morris to continue. Yes, Morris.
These are some of. I think it's a mixed bag of questions and statement of fact that the NDC wants the EC chairperson to admit. So that it goes on record that while making the purported declaration of the presidential election result of 7th December 2020. On 9th December 2020, Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, stated that, and I quote, the total number of valid vote cast was 13,434,574, representing 79% of the total votes registered voters. They also want to put on record that while making the purported declaration of the presidential election result of 7th December 2020 on 9th December, Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, stated that second respondent of the MPP obtained 6,730,413 votes, representing 51.9595% of the total valid votes cast. And so, George, these are, part of the many questions and facts that the NDC wants to establish. That Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, also stated in the purported declaration of 9th December 2020 that currently, and that's a quote, the election results we have declared exclude that of the Chiman South constituency. Be some difference, and so if the EC said at the point that the Techiman South constituency result were infinitesimal, they are trying to challenge that, and so you realize that these questions are modeled along the petition that they filed, even though the EC has said that some of the questions are outside their petition, so they are trying to come behind the back door. That Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, gave a figure of 128,018 as the voter population of Techiman South constituency. They like the EC chairperson to respond to that specifically. That adding the voter population of Techiman South constituency to the total valid votes of 13,434,574 valid vote cast announced by Mrs. Jane Mensah, Adukwe Mensah, the chairperson of first respondent, amounts to total valid vote cast of 13,562,592. Number 9, that first respondent votes as announced by Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, in her declaration of 9th December 2020 was 6,730,413, amounting to 49.625 of 13,562,592 as declared by the Electoral Commission. That when the percentages of the valid vote cast and standing to the names of each of the presidential candidates as announced by Mrs. Jane Mensah Adukwe, the chairperson of the first respondent, on 9th December 2020, are summed up, they would yield to a total of 103. So you realize that in the petition of the NDC, they have said that even though the EC says that this figure is a total valid vote cast, if they collate the various figures that the EC gave to the various presidential candidates, it's amounted to 100.3% of the total valid vote cast. So some of these questions, they would like her to just confirm, so that maybe when they start cross-examination, they can refer her back to some of the things that she confirmed or denied at this particular, early stage of the case. That Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, in her purported declaration on 9th December 2020, stated that the results from Techiman South constituency were not yet available. That Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, in a declaration on 9th December 2020, stated that even if all the 128,018 votes of Techiman South constituency were added to the votes standing to the name of petitioner, that would not change the results. That Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, refused to accept a letter, which is an exhibit they will be presenting before the court, Exhibit B, written by the NDC to her, in which the NDC, through its authorized and accredited agents, raised concerns and notified her of material errors in her collation of the results of the 7th December 2020 presidential election. That a purported correction of figures in the declaration made by Mrs. Jane Adukwe Mensah, the chairperson of the first respondent, was by virtue of an unsigned press release of first respondent on 10th December 2020. And George, you realize that this was a topical issue, which is contained in their petition. So they would like her to just answer these questions from the beginning before we continue.
All right, so we're still waiting for the Supreme Court, when they come back from their recess, to come out with the final ruling, which will determine whether these questions and even more of such will be answered by the first respondent, which is the Electoral Commission. You're still live with us here on GTV. We are live on GBC News. We are also live on Facebook, Ghana Broadcasting Corporation, on the internet, gbcghanaonline.com. We're also live on radio. In Accra here is Unique 95.7, and across the 16 regions of this country, now various regional FM stations and community radio stations, bringing you extensive coverage of the 2020 presidential election petition, which is currently live going on at the Supreme Court. We're waiting for a ruling. The petitioners actually raised an issue and certain questions that they want the Electoral Commission, which is the first respondent, to address. That's the ruling we are waiting for now, and still waiting for that from the justices of the Supreme Court. But before we even continue with our conversation, don't forget to put on your nose masks wherever you're going, all right? And adhere to the various protocols. It's very, very important. You wash your hands with soap and running water. You try as much as possible to use the hand sanitizer. Not even try as much as possible. Use it when it is available. And forget your nose masks. You need to be that responsible. Protect yourself, protect your loved ones, protect your family. And let's protect ourselves as we try as much as possible to reduce the cases that we're recording so far. Yes, Maurice.
Right, and so we are live on Facebook at the Ghana Broadcasting Corporation. You can join us with your comments, your thoughts, and your suggestions as you watch live proceedings. We have access to the Supreme Court and its environs, and we will bring you whatever happens at the Supreme Court. As we speak, the court is gone on a short recess. They will be back to make a ruling on that particular case, which is before it at this particular point. But we still have on via Zoom Dr. Kweku Ajiman-Budu, who has been with us since morning, trying to help us understand the legalities and the very complex issues in this 2020 election petition. Yeah, so counsel, if you can hear me, thanks for joining me once again. What would you think was the strategy? What was the NDC seeking to do with this particular amendment?
That's a question that's not, I don't necessarily see it appropriate to answer, because that's essentially preempting or dealing with substantive matters that are before the court. What I can tell you is what transpired in court, which we were all witnesses to, or at least we had the benefit of seeing that. And I mentioned it earlier on that they were requesting the admission of certain facts, as well as seeking or praying the court's permission to serve interrogatories on the first respondent. And that's what has been dealt with, or the court is dealing with for the past, also where the counsel for the petitioner made submissions in support of their position, and the first respondent also responded, essentially suggesting that these are matters that have been dealt with because the law, the Public Elections Regulations law that was enacted for the purposes of the conduct of the 2020 elections, dealt with all the processes that were to the Electoral Commission were to undertake during the election process, from the polling station level to the constituency collation center to the regional collation center, which essentially was a new addition in the electoral hierarchy, or the submission of results, because it seems as though this was the first time in the Fourth Republic that a regional collation center was introduced as part of the election processes. So that's what the first respondent was suggesting, that they don't see the need for going through this whole thing because the law already provides for this. So they do not really see the relevance of asking them to answer certain questions which essentially have already been answered, because the law already provides for that. And there was a little back and forth, and the court went on recess, and I believe they'll be back shortly to give their ruling on the matter. We will then know what the next stage or process will be.
All right, Doc, before we lost you on the telephone, you were explaining to us what's going to happen after the ruling is given, whether we're still going to be within the pre-trial or we'll move into the case itself. You were explaining to us before we lost you there on the telephone. If you can just go over that bit of it for us.
What, can you repeat the question?
I said before we lost you there on the telephone, you were explaining to us what is going to happen after the ruling is given, whether we're still going to be within the pre-trial stages or we're going to move into the substantive case itself.
Oh yes, so we're still in the pre-trial hearing stage, as you're all aware of CI 99, which amended CI 74, which also amended the original CI 16. The Supreme Court rules sets out the processes for the conduct of an election petition. So the pre-trial hearing is supposed to last, I think, I'm not sure of the number of days. I'll check and get back to you. I don't want to say something that would be wrong. But we're essentially in the pre-trial hearing stage. And once that is done, I don't know whether that's going to be done today. It's possible it's not going to be done today. But once that is done, then the rules provide that the hearing proper will proceed, or will proceed with the actual hearing of the petition. And like I said earlier on, all that is happening right now are sort of rudimentary things that do not necessarily go to the heart of the matter at hand. And these are things that we need to get out of the way so that the hearing proper will start. We know that the petitioner has listed that he is going to call 5 witnesses in his petition. So we'll see how the court deals with all those things once we are done with the pre-trial hearing stage and once we enter the trial proper.
All right. And still within the pre-trial, to help us understand further, are we going to have any of the respondents also raising certain issues or certain things within the pre-trial stages?
We saw what we've seen the petition,
yes.
And the answer that was provided by both respondents, the first and the second respondents. One of the things that's out is the fact that they intend to raise preliminary objections in terms of the matter itself. They want the court to dismiss the matter as not really disclosing any particular course of action, because according to the first and the second respondents, to a large extent, the form and manner of the petition do not meet the standards of an election petition as envisaged under Article 64 of the 1992 Constitution and the Supreme Court rules. And generally speaking, some of these matters are usually decided during the pre-trial stage, and once assuming it is upheld, then it goes to the heart of the matter and the matter ends. And if it's not upheld, then we move on to the trial proper. So generally speaking, these are some of the things that you would expect to see during these stages. Another thing too that I believe I mentioned earlier is the fact that the issues for trial are set out, generally speaking, at this point in time. So I made mention of the fact that in the 2012 election petition, there was the issues that the court set down as to whether there were irregularities, malpractices, and all that, and whether or not, if these irregularities, malpractices existed, whether it affected the overall results of the case. So those are some of the things that generally you would expect to be dealt with at this stage, so that once those things are dealt with, once the ground rules are set out, everybody knows what we're going to do once we move on to the hearing proper.
All right, and all this is part of the 42 days?
Yes. Yes, we're still, everything falls within the 42 days. And like you know already, if you look at the rules, the Supreme Court rules as amended, the 42 days, I believe, starts from the date on which the petition was actually filed. And in this particular case, it will be the 30th of December or so. Correct me if I'm wrong. That was when the petitioner filed the petition. That's why many people are hoping and expecting that by the beginning of February, thereabout. The trial itself is supposed to take, I think, 5 days or so. That's what the rules provide. So that's what we expect that will happen or will transpire before, so that it will be dealt with in a fast manner. But and this, like I said earlier on, is because or part of the reason why we now have these rules is the fact that the last election petition that we had, it took several months, and we know the effect and impact that it had on the country. Generally, it was as though we were in a limbo, because there was a serious issue of the challenge to the validity of the election of a president, and we know that the Supreme Court can make orders that will essentially reverse, assuming they accept the fact that the person who was deemed to have been validly elected by the EC pursuant to Article 63(9) was actually not validly elected. And I mean, it could create a situation where there's uncertainty and all that. So I believe this was part of the reason why the Rules of Court Committee decided to make such amendments to the rules to ensure that the whole petition is expedited and done in, it being expedited doesn't mean that all the substantive issues will not be dealt with. They will be dealt with nonetheless, but it is possible clearly to have it dealt with within a relatively short period of time.
All right, and finally, I mean, we don't know what the future holds for us. So is the 42 days cast in stone?
Well, according to the rules, that's what it says. So, I mean, at this point in time, that's what we are going by. That's what the rules say. And the subsequent election manual, the fourth edition, I believe, that was launched by the Judicial Service, reiterated that point. Several justices of the Supreme Court have reiterated that point as a means of expediting such election petitions, because we know the kind of uncertainty that exists. And it even goes beyond just us in Ghana. I mean, the international community will be watching. Investments may be affected. Foreign direct investments, which we so need, may be affected if there's uncertainty in terms of political situation in the country. But I believe that from 2012, when we had that first sort of foray into an election petition proper, we have learned some lessons, and these are the types of lessons that have informed the rules that have now been enacted to guide this process from henceforth. And I believe as time goes on, these will be revised depending on the exigencies of the situations and the lessons that we learn from what transpires in this petition and all that.
Just on the side, I mean, you are a law lecturer, and you heard the law centers at Gimpa Faculty of Law. This entire process that's happening now, what does it mean to the legal profession, especially to you as a lecturer and other law lecturers, and also law students too, who will be watching this entire exercise?
It's an exciting period for us generally in the legal fraternity, because such cases tend to build on our law. I mean, since the 1992 Constitution came into effect on 7 January 1993, we hadn't had an election petition until the 2012 elections, where we had that petition, and we realized that it took such a long time to deal with, and subsequently we made amendments to ensure that we deal with it in an expedited manner. So one of the things that this petition does for us is that we get new case law. So we can compare the 2012 election petition to the 2020 election petition to see if there were similarities. But we already made mention of the fact that it seems as though the crux of the issues at play in this particular election seems different from that which was at play in the 2012 election, because in the 2012 election petition, the petitioner was suggesting that he rather was validly elected, and so was praying that the court agrees or sides with him in that regard. But in this election petition, the petitioner is not saying that. The petitioner is saying, on the basis of the declaration made by the first respondent, or the chairperson of the first respondent, that no one was validly elected. No one met the constitutional threshold of more than 50% of the total valid votes cast. So the dynamics are slightly different in this particular instance, but it will be exciting to read the final judgment of the court once it is done and once it is published. It will be a good basis for teaching our constitutional law students how an election petition is conducted, some of the issues that the courts had to deal with and how they dealt with. For instance, in the 2012 election petition, one of the key things that were decided was the issue of the non-signing of pink sheets. And the Constitution provides that the presiding officer shall usually imposes an obligation on the duty bearer to do that which he is supposed to do. But the Supreme Court, or the majority of the Supreme Court, held that to take that doctrinaire approach in interpreting the Constitution, and remember, Constitution is a living document capable of growth. It grows, it reflects the values of we the people. So the fact that the Constitution is saying that the presiding officer shall sign the pink sheets before proceeding to announce the results at the polling station, and some of these presiding officers have not signed the pink sheets, will not necessarily invalidate the votes, because the petitioner was not challenging the authenticity of the results contained on some of the pink sheets that the presiding officers did not sign. So the court used what is referred to as a modern purposive approach to interpretation to suggest that even though shall usually imposes an obligation, a positive obligation on the duty bearer, within the context of elections generally, and within the context of an election petition, if you take that doctrinaire approach, what you will do is that you end up disenfranchising people who had nothing to do with the non-signing of the thing. So, for instance, if a number of presiding officers decide not to sign the petition in the stronghold of one of the parties, for instance, doesn't mean that you're going to declare the votes therein as not.
Yeah.
So that will be disenfranchising the people who had nothing to do with what the presiding officer did or did not do. So these are some of the things that it builds on the Constitution. It provides guidance in terms of how we subsequently deal with some of the issues that pop up in our elections and in our law generally. So those are, in a nutshell, some of the things or the benefits of the election petition.
All right, and for a law student, what would you expect of them? You're a lecturer. Would you tell your students to make sure that they don't miss any single case at all throughout this process? For law students, what do you expect of them?
I mean, of course, I would expect any law student, first-year law student for that matter, because constitutional law is usually dealt with in the first year, should this whole process should be of interest to law students generally, not even those in the first year, but generally speaking, because these are relevant matters that go to the heart of our Constitution and the democracy that we are practicing. So if any law student worth their salt should take this process seriously, because at the end of the day, questions will be set. You never know, there could be compulsory questions and stuff that could be set revolving around such landmark cases in our constitutional jurisprudence. So those are some of the things I'd expect, yes, them to take it seriously, because if not for their own edification, for their greater interest in studying the law and wanting to be lawyers eventually.
Okay, yes. All right.
So, Doc, I've been monitoring social media, and I see lawyer Chachu Chikata is trending. They say that Chikata is a law. As a law lecturer, he was part of the 2012 petition. He is here again. What does his participation in this process, this petition, what does it mean to the legal profession and, for that matter, the study of law?
I mean, I can't really comment on such personal issues. I mean, you know very well that I won't be able to comment on such personal issues that deal with individuals and all that. This is not the appropriate forum to deal with some of these things.
All right. On that safe answer, I have a question concerning the Supreme Court. We know that cases like this will have to go to the Supreme Court and all that. As a lawyer, if you're going to appear before 7 judges, not just any judge, but these are judges who really understand what the law is, they understand the Constitution. If you're going to appear before them in the Supreme Court as a lawyer, how prepared should you be? And what things should come in play here in facing such judges, especially having the Chief Justice being part of such a panel?
Ordinarily, appearing before any court, you need to have prepared. Preparation is key. You can't purport to appear before a court, generally speaking, without having prepared thoroughly to prosecute your agenda. And so seeing how serious this matter is and having such high stakes involved in terms of the questioning the validity of the election of a president, one expects, and we know that lawyers that appear will be appearing before courts generally, and the Supreme Court in particular, would have prepared thoroughly. And we can see that in play as we saw proceedings a few minutes ago. It's clear that all the lawyers for the respective parties have thoroughly prepared and are properly before the court. So yes, generally speaking, you would have to prepare before you go to court, because not preparing simply means that you are going to have problems. For instance, assuming a law has been passed, for instance, that repeals an existing law, and you haven't prepared enough to know that there's a new law that repeals the law that you're seeking to rely on. then there will be embarrassment. Then you will find yourself wanted, because clearly repealed law is not law. So that's what goes. You need to thoroughly prepare, generally speaking.
And how important is procedure in the practice of law, and especially what's happening? Because on the first day, which was last week, and today's sitting, you've realized that there are particular ways that certain things or the cases even have to be conducted. How important is procedure in matters like this and in the courtroom?
Procedure is very important. I mean, in as much as there's a substantive law, there's the procedural law. There are the steps that you ought to take in presenting your case. So, for instance, with this election petition, the petitioner didn't just get up and walk to the Supreme Court saying, I have a case and you should hear it. There are processes. You need to file an election petition in a prescribed form within 21 days from the declaration of the results. There are certain things that you need to comply with. There are rules that guide the conduct of the trial, for instance. So procedure is very important when it comes to the dispensation of justice. And as much as the substantive law is important, the procedure is equally of great importance as well.
Can a case be dismissed because the procedure is wrong?
It's possible. For instance, you're supposed to go file an election petition. So if you go by writ, a writ is not the same as an election petition. So the procedure would have been wrong in that instance and the matter will be dismissed. We saw that happen, I think, was it the Roger Metununu case somewhere, I don't remember the exact year, but they basically went to court by virtue of a writ challenging certain things that went on in terms of the election. And the court were of the view that it seems as though the matters that were being raised were matters that could have properly been brought within the context of an election petition. So to the extent that that has not been done, or that was not done, then the right procedure was not complied with. We've had instances in parliamentary election situations where people, instead of going via a parliamentary election petition, which is also provided for by the law, have in the past gone by writ of summons, which has been deemed not to be proper. So yes, procedure is of critical relevance, and it could make or unmake your case that you seek to build.
Let's assume that you got the procedure right in filing your case and all that, and in court there are certain procedures that went wrong. Can it also determine the outcome of the case in court during the trial itself?
I don't understand your question.
The question is that you filed the processes and you went through it procedurally, then the case is being heard in court. In court, during the hearing of the case, is procedure also very important during the case, when a case is being heard?
Of course, it's very important. It's critical. Procedure is at the heart of the law, generally speaking, and when dealing with court cases, because like I said, you just don't go to court and just start addressing the court or just go and do anything that you want. There are rules that spell out exactly how to appear properly before the court and make your submissions in the proper manner before the court. So yes, to that extent, yes, procedure is that important. Like I'm saying, it's not as though the substantive law is not important, but what I'm suggesting is that the procedure is of equal importance, and it could make or unmake a case that you're trying to make.
All right. But we'll leave it here. Thank you very much for your time. We'll get back to you. We're still waiting for the ruling on that particular case. So we'll get back to you as and when. Thank you very much.
Hopefully there are questions I'll be able to answer. Not questions that send us all within the realms of contempt.
That's fair enough. Thank you very much, and enjoy the rest of your day, and we'll still get back to you when we have to.
Thank you.
All right, just heard from Dr. Kweku Agyemang-Budu, who is a lawyer. He's also a law lecturer and also the head of Law Center's Gimpa Faculty of Law. If you're just joining us, it's the live coverage of the 2020 election petition. It's live here on GTV, that's Ghana Television. We're also live on GBC News. We are live on Facebook, Ghana Broadcasting Corporation. On the internet, gbcghanaonline.com. On radio, on Accra is unique 95.7 megahertz across the 16 regions of this country and our various regional and community radio stations. So we're giving extensive coverage of this particular case that's going on in the Supreme Court, all by the Ghana Broadcasting Corporation. I'm here with Morris. My name is George. Stay with us. We're going for a quick break. When we return, we'll let you know what's happening in the Supreme Court. We'll be right back.
You are live.
Alright, and so we still live here in the we bring you proceedings from the Supreme Court, the presidential election petition. We will read biggest viewer of the country and George. I mean, this is our first comment. It says hi. Scatter lawyer one. Hey, see, when will you tell the truth? I mean, so GTV, good job watching you live from Kumasi. I mean, this is a very sensitive matter, and so if you want to send us any message, you want to be censored, and you know exactly what you are writing to us. I also think it will be fair if the court will allow the 13 questions from Chachu for EC to answer for smooth processing and clear proceedings from Daniel Kasua. So that's what the judges are going to determine, whether they allow the EC to answer those questions. That's, will be their sole job to do, and not, any other person. Good morning, Mr. George and co. In fact, may God bless you all for the good work that you have been doing for Mother Ghana. To me, for the interest of all Ghana and the world, the first respondent should respond to the questions from the petitioner so that it will be clear to everyone listening or watching. Thank and continue with a good job. In fact, some of us are learning a lot from the proceedings. Hello, good morning. I am watching you live from New Edubiase. My name is Yao Edu. As you were reading the NDC's petition, I realized point 9 is an error. I mean, we can talk about that. Good morning. I'm seeing the program live. Thanks so much. My personal view of this petition is corruption and fraud. So Mr. Mahama should leave them and forget it and handle everything to God. We are all seeing what's going on in the country. That's from one of our viewer there. Okay, so the NDC party have nothing to do at the Supreme Court. That's your opinion. Okay, so this one says, hi GBC TV, great work you are doing. We NPPs believe all will go well on our favor. Kwame Gideon, I think he is writing from Osu. This one says, good morning. My concern about this whole petition is waste of time. NDC secretary said. All right, so as I said, we want to be very censored in some of the messages that we send to us, because this is a very sensitive matter. We would not like to enter the realms of contempt, as Doctor, has been saying. Right. So you guys, do you not know that the volume is low? Okay, so we'll have to work on the sound. So our technical guys will have to take a cue from there and check the sound. The case itself is paving the way for the truth that all the questions raised must be answered vividly for the whole of Ghana to watch and listen, for them to draw their own conclusions. God bless us all, said them from East Legon, sent us that message. This one says, hi, the Supreme Court resumes hearing of election petition today. We thank God, just waiting to see how Jane Mensah will prove that an error in mass will not affect the results, and how 103% total percentage EC result declared on 9th December will be explained. So this one says, good morning GTV. JM should just accept defeat and stop wasting resources. I mean, that's the opinion there. This one says, we must tell the truth in this world, because if you look at this election result, JM won the election, but the EC make a lot of mistakes and take the Nana as the winner. All right, so that's from one of our viewers there. Hi, good morning. I'm watching live from outside Ghana. You didn't tell us where specifically you're watching us from. This is Martin Amevo from Adenta Lakeside Estate. I pray Ghana grabs the peace bread, because I believe there is no political party or religion higher than the truth, and always the truth leads to perfect peace. Thank you. Good afternoon. That's from... All right, so we'll see whether that's possible.
All right.
Right. So this one says the NDC should forget because they have no case in court. That's in Chi. I'm not able to, read all that. So, George, these are messages
up there
coming in from right. So from our viewers, this one says, "Good morning from Otumfo, the convener of Crossfire Ghana. Ghana is progressing in democracy. We should do all we can to protect it. I pray Bagbin wins. We have to condemn the attempt to snatch and destroy." I think these messages were long ago. Well done. And can you please repeat this program? If yes, when? Thanks, Rikichi from Alajo. Good morning. I'm Eben from Kwabenya.
Let's take the down one.
This one?
Yes. No.
This one?
No. Yeah, I think that's one released.
Good afternoon. I'm Eben, watching live from Kwabenya. Chachu. Lawyer 1 to be that. Chachu is the law, and the law is Chachu. I pray the lordships will grant the petitioner request at the pre-trial. That's your prayer. We'll see whether that will be answered. Good morning, please. For justices or for justice to prevail, everybody should bring all of their pink sheets for public collation. Simple. We all know 1 + 1 is equal to 2. That's your suggestion there. This one says, I am glued to GTV enjoying the analysis. Kudos and thanks to lawyer Ajiman Bedu from Francis Adai in Kumasi. Right. This one says, GTV, you have always been on point. Thanks a lot for this telecast. It's also good for some of us who are studying law. Mark Ashite, the Psalms Eagles from Takrade. Hi, I just want the judges to deliver a fair and unbiased ruling. You guys are doing well. David from Takrade. Great job. Okay, Abdul and the team from Yakubu Ibn Chambers. Can executive function without the legislature? Should that happen? I think that these are earlier messages.
Just go up a bit. I'm sure this message might be down there.
All right, so let's see this one.
Yeah,
it says that.
That's it down there. That's the last message down there.
Great job, Supreme Court from Yakubu Ibn Chambers. Right. So, good afternoon. I pray the court rule for re-election. RKB from Wasa Subri. That's your prayer. Let's see how it goes. Hi, good morning, GTV. You are doing a great job. Keep it up. Thank you very much for the compliment. I believe the question on transmission of votes is a national security issue and must not be made public or answered by the EC. Adenta Kumi. I believe the question, okay, so it's the same question repeated here, George, right? So this one says, good morning. I'm seeing the program live. Thanks so much. My personal view of this petition is corruption. All right. So here we have signals. So we'll go back to the.
Cool. All right. So let's go back to the Supreme Court now.
The ruling of the court. The petitioner applicant has prayed this court to grant the application to serve interrogatories. The basis for the application, as argued by learned counsel for the petitioner applicant, is to assist the court to narrow issues for the trial of this petition. Interrogatories under common law is discretionary. It should be granted or refused when all the circumstances are taken into consideration. It should be noted that the questions seek to elicit should relate to the issues raised and the relief sought in the petition. Interrogatories must be relevant to the issues and relate to the matters in controversy between the parties. In this petition, the petitioner and the first respondent. The court is of the opinion that the crucial issue of relevancy has not been established in this application. Reference was made to the 2013 election petition titled Nana Dankwa Akufo-Addo and two others versus John Dramani Mahama and two others, 2013 Supreme Court Organo Law Report, Special Edition, page 50, in which an application to serve interrogatories was granted by this court. However, subsequent to 2013, several statutory amendments have been made by CR 99 of 2016, which has restricted the practice and procedure of this court as regards election petition. Indeed, Rule 69C4 of the Supreme Court Amendment Rule CR 99 directs the expeditious disposal of the petition and sets timelines for this court to dispose of the petition. It implies that even amendments ought not to be granted, as well as joinder of parties. Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR 90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
You are grateful to the court.
I am most grateful.
Yes, please may I have your attention. Indeed, we set today, we adjourn the matter to today for case management so that we can have the consensus from both parties and proceed to hear the petition. So we hear from you the issues which you think should be set down for try. Yes, Mr. Chikata, we want to we are seeking the assistance of both counsel to give all counsel in this case to give us some assistance in arriving at issues so that we can proceed to make consequential orders.
Well, my lords, before we get into that, I may say that we will urgently require a certified true copy of the ruling that you have just delivered so that we can advise ourselves in respect of that. And if we can have it by the end of the day, that would assist in the further processes that will take. Now, secondly, my lord, as I indicated right at the beginning, we have served a request to admit facts, which is a request we have served on the first respondent, and we have also served a request to inspect documents. Now, my lord, in respect of the request to admit facts, again, that is in the nature of a process of discovery, which also comes under CI 47, and we have the clear understanding that in respect of that also, the number of days within which we have indicated 3 days within our request to admit facts. Now, that is not an application before you at the moment. I recognize that. However, I'm drawing your attention, the attention of your lordships to it, because that will also affect whatever other steps are being taken in respect of this case. So I think we recognize that you have just given a ruling about the operation of CI 47 and how it's affected by the subsequent CI, which we will advise ourselves on once we have it. And I think that that will guide the process of our recommendations in respect of the case management. The final thing I will say is that I think, as is fairly normal, we are quite happy to set down the issues that are arising from the petition and the respective answers and put that forward so that it is considered by council. I do not think that is a process that is easily done just on one's feet in a courtroom to try to determine what are the issues. I think that a normal process is perhaps for us as petitioners to put forward issues, and we are happy to undertake that with as much expedition as is consistent with the interests of justice.
In what form?
Well, that we
want you to file issue so that we settle on it. Maybe by tomorrow.
Well, my lord.
Mr. Kutompa. Yeah. Mr. Chikata.
My lord.
Yeah, please, can you oblige us so that if...
My lord, I think tomorrow is a stretch because, one, I don't think we can respectfully do it by tomorrow because, first of all, respectfully, we are going to advise ourselves in respect of the ruling you've just made. We are going to take that into consideration because your ruling, as we heard it, seems to relate to the operation of CI 47. And so, since these processes of issues, they are not provided for in CI 127. The CI 99, they are not provided for in CI 99. There is no specific, so again, normally we would be guided by what happens in CI 47. But we need, that's why we need to understand your lordship's ruling, and once we get it, I think we will know what steps to take. But I think tomorrow it will not be possible for us to submit.
Try to be a bit flexible, because if you look at the operative rules, there's no provision for amendment. But we thought it is inherent in the court of law, to be very flexible, to allow amendments. But whatever it is, if tomorrow is not convenient to you, because we thought, having settled the pleadings, at least, you can unearth the issues. Yes, by tomorrow, so that we set the, what do we call it, the case management in motion. Yeah. Yes.
Yeah. But if Thursday is acceptable, by Thursday we should be able to put.
Yeah. Yes, Mr. Kutampa. Excuse me, please.
My lords, today was set up for case management, and all lawyers know that case management involves determining the issues for trial, and all of us should have been prepared for that. It is not acceptable that any counsel may suggest that when a date has been fixed for case management, especially in the circumstances of these proceedings where expedition is very paramount, to come to court and make an application that they should be given time to think about the issues. That is highly unacceptable.
Please, so, it was overtaken by events because there was an application which had to be determined.
No,
yes.
No.
And
my lords.
Yeah. We adjourned. The court adjourns a matter. We adjourned it to today for pretrial.
Yes.
Case management.
Yes.
Then an application was filed.
Yes.
And we thought that it was prudent on the part of the court to take the application, and we've taken it. So if we adjourn it tomorrow, we hope that you can do us a favor and file the issues. Yes.
Very well.
Because we don't want to impose the issues on you, but ultimately it's the court which will have to consider the issues which parties have filed, so that we proceed on the common.
My lords, if we can take a cue from the precedent of the 2013 petition, this matter of issues to be tried was determined in open court. So it seems to me that if your lordships are directing that we come tomorrow for that, we should come and read out our issues and for the court to take up the issues.
Okay.
Because filing these matters may take some further time.
If you prepare it in the morning, you can have it at the registry. Sorry, file it at the registry.
We are ready.
In the morning.
Very well.
We are ready. We are ready.
Lords, we are just concerned that this matter be dealt with very expeditiously.
We are ready. We are ready.
My lords, I believe that I've indicated that it would not sacrifice expedition if we had until Thursday, because we also need access to a ruling that you've just delivered. Yeah.
Let the issues for determination be filed by tomorrow before 9:30 a.m. The case is adjourned to 9:30 tomorrow a.m.
My lords, just for clarification, I believe that beyond the determination of the issues, all other issues of case management will be dealt with tomorrow. Yes, yes.
Rise.
Sitting till 9:30 tomorrow morning, and this followed the decision that was made after the application by the petitioner's lawyers for what they call interrogatory application to allow the petitioners to ask the EC chairpersons certain questions, especially regarding anomalies and subsequent corrections of the results as she declared on December 9. One of those issues had to do with the fact that the petitioners claim that at a point the results declared by the EC, when collated, would amount to more than 100%, indeed 100.3% is the figure they are talking about now. One of my colleagues in the Supreme Court joins me right now. So let's summarize everything that happened today. So there was that application, really to what end?
Yeah, there were 12 questions that they sought to ask the EC if the court had given them the go-ahead. Apparently, in the wisdom of the court, that could not be granted. And so the Supreme Court is now saying that they have to look at the case itself and what to determine as case management as to the way forward. So the Chief Justice was asking the three counsels of the various petitioners, the petitioner, the EC, and then the Nanado side to sit together and think through what's next. In the wisdom of Mr. Chikata, he said that because the ruling has come in the way, he would have loved to have access to the ruling and go through it. And so he was suggesting that it should be Thursday. But Mr. Kotompao, on the side of the President and Akufo-Addo, was saying that they all came to court with the knowledge that they're going to proceed from start the case management and go ahead. So they are prepared. But the Chief Justice still insists that they have to go and sit down and then talk through, because he used the word want to be flexible. While they were saying that they need to deal with the matter expeditiously, he also said that yes, they want to deal with this expeditiously, but they need to be flexible and move ahead. So the decision is that you're going to give them access to the ruling.
And now we see some of the lawyers for the second respondents coming out at the moment. We see Mr. Frank Davis as well as
the court dismissed the petitioner's applications for interrogatives. You were not opposed to it, but you made comments regarding that. What are your response to the court decision now?
Well, thank you. Just to correct you, we were opposed to the application, but our opposition was on legal grounds because we hadn't filed an affidavit in opposition. So indeed, we were also opposed, much as first respondent was also opposed. Well, the real work in court has started. All this propaganda of having won 2 goals to 0. This is the first application that has formally been moved before the court. The application for a televised broadcast had already become moot because the court had already set in place the procedures for a live telecast. The application for interrogatories was dismissed outright by a unanimous panel of 7. This tells you that the petitioner has a long way to go insofar as this petition is concerned. There are ground rules which have been set for this petition, and the Supreme Court is not going to allow for unnecessary and interminable delays in the hearing of this petition. We are gladdened by the fact that the opposition we mounted was exactly what was rendered by the Supreme Court in its ruling. We heard lawyer for petitioner talking about time to have certified true copy of the ruling. Well, that is his right, but that would not delay the trial. The courts have indicated quite clearly that tomorrow morning we are here for the pre-trial. Tomorrow morning at 9:30 a.m. we will be here. Indeed, just to let you know that we were ready and prepared with our issues, because the last time the court directed that it was going to be a pre-trial, every lawyer knows that when the case is adjourned for pre-trial or case management, you have to prepare your issues. And if you bring an application to court, you either know that the application will be granted or dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business. But yes, the real case in court has now started.
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth? We came to court when on the 14th. If indeed you wanted an application to be heard from the 14th that we came to court, we had an intervening period of a Friday. You wait until yesterday before you file the application for interrogatories. And even this morning, that was when they filed the request to produce documents. I mean, what at all can be the reason for that? You can answer. What at all can be the reason for that?
You suspect they are delaying?
I say, what at all can be the reason?
You tell me what you think, sir.
The court said that there should be expedition. The court said there should be expedition. So that answers your question. Okay? When the court has invited us to come for case trial and management, the pre-trial, it means that you have to have your issues before you come to court. Whether you have an application or not will depend on the ruling that the court gives. But that does not preclude you from coming to court with your issues. And that is exactly what they failed to do.
Very much. Thank you. And that was Mr. Frank Davis, who is one of the lawyers for the second respondent in this matter, President Nana Addo Dankwa Akufo-Addo. Thank you very much, sir. And we'll be talking to a lot more of the lawyers here, and we expect that in a short while the petitioners' lawyers will arrive, and we will be speaking to them as well. Thank you very much. We'll be talking to
You can go. Let me do the case.
Some of them regarding what happened in court today.
For interrogatives were dismissed by the court. Your response to that?
Well, thank you very much. The court today did something that astounded a lot of us, and that is because it ruled that we could not bring an application for interrogatories based upon the existing rules. And if you listen carefully to what the learned, Chief Justice said, that given the new rules, that is CI 99, we could no longer bring an application for interrogatories in respect of election petitions. That really is surprising to a lot of us as lawyers, because basically what the court has done is to overrule its own decision in the 2013 election petition without according reasons as required by the Constitution and existing practice and precedent. We think that the court sidestepped the basic issues that were brought before it. We think that the issues were very relevant because they went they go to the meat, the integrity of the pleadings that were filed, that is the petition, as well as the respective answers. And in fact, if you were listening, counsel for the first respondent did admit that our interrogatories were relevant, because he said that those interrogatories raised issues that had been answered by their answer, as well as the answer of the second respondent. And so for us, relevance was key to the application that we brought. And we're very shocked that the court did two things. First of all, by sidestepping its own decision in the 2013 election petition, one, by a 9-member panel. Okay, that decision was cited by learned counsel for the petitioner, Mr. Tachu Chikata, to the court. And then secondly, by implying that there has been kind of an implicit amendment of CI 47 that we think is very I don't want to use strong language, but I think that it is legally unacceptable, legally untenable. So we have requested for the ruling of the court, and we have told the court that we will advise ourselves with respect to the ruling.
Your colleague, Mr. Chikata, was asking for more time in order to get the ruling before the case proceeds. Is it your contention that this ruling potentially has an impact on the matter and how it proceeds?
That is so, and as he said, he indicated to the court that we're going to advise ourselves. So we'll look at the ruling more carefully in light of existing precedent, and then the statutes that were cited by the court itself, and then we will come back to the court to find, to determine whether or not we will ask the court to take a second look at its own, decision.
Your colleagues demonstrated the crucial issue of relevance in the first matter. They said you couldn't demonstrate the crucial issue of relevance.
No, we didn't need to even, I think that Ms. Chikata eloquently dealt with the issue of relevance, by, for instance, taking the court through, step by step, the relevance of each of the questions that we wanted the Electoral Commission, to answer. And then also, when Learned Counsel for the first respondent was on his feet, he himself pointed out quite clearly that the issues we raised were contained in their answer. And our application for interrogatories was basically to elicit answers that will lead to an expeditious determination of the matter, so that we don't have to take them to cross-examination and have a lengthy trial, as you saw in 2013. And that is why we wanted to narrow down the issues and make sure that, when next time we are in court, we are dealing with very specific factual matters before the court.
We spoke to your colleagues on the other side. We spoke to your colleagues on the other side. They make the point that you don't need a ruling to proceed, and that they believe that you don't want an expeditious hearing.
No, we are committed to an expeditious trial. In fact, our application, on the contrary, was the one that was designed to lead to an expeditious trial. And we are very ready for this trial. They should not, they thought this was going to be a walk in the park. And what they saw today is just a tip of the iceberg. Thank you very much.
Thank you very much. And so we have been speaking with representatives of both parties, particularly the petitioners' lawyers and also the lawyers for the second respondents, in this case, Nana Adodankwa Ekufado. And for those who just joined the feed, what has happened is that earlier today, Mr. Chikata, who rose up as counsel for the petitioner, Mr. John Dramani Mahama, did call for the court to grant him what the lawyers call interrogatory application, so that he would be able to pose certain questions to the EC boss regarding the declaration of the results. The court went on recess, returned after about 30 minutes, and ruled against that application, and has adjourned till tomorrow, when the substantive matters will be debated in court. Again, my two colleagues, Barbara Kuma and Edward Nyako, join me as we wrap up events for today. So, Barbara, essentially, what happened in court today?
Okay, just like we said in our earlier commentaries, the court today was supposed to have sat on a case management. That's case management conference. They were going to decide on the issues that the petitioner and the respondents were raising, so that they would set out how the proceedings for the main petition was going to go. But before that could have been raised in court, the petitioner, that's the former President John Dramani Mahama, actually filed an application yesterday seeking the leave of court for the first respondent, that is the EC, to answer certain specific questions. So that's the court, they moved that motion this morning, and they sought the court to determine or order the EC to answer the questions that they raised in their follow-up applications. But from what we said earlier, the respondents, that's the EC and the president's counsel for second respondent, opposed the application, citing various reasons. And so the court raised for close to 45 minutes to go and take a decision. And they came back and they said, well, for an interlocutory application, it should be very relevant to the situation in the petition. And they didn't see any relevance to the relevance of the application to the issues raised by the petitioner and then the respondent. So they couldn't allow or grant that application. And so after that, the court adjourned sitting and wanted to determine issues raised by the petitioner and the responses by the petitioner, so we could go forward or move forward from there.
Where we are now. But Edward, yes.
And so what I want to add is that listening to Dr. Dominic Ayini of the petitioner, it indicates that there's a likelihood that the NDC might come to appeal or seek for a review of the decision of the court this morning. And so if you listen to him, he said they've sidestepped the words he used. They sidestepped their own ruling, and therefore they want to go and look at it and come back to the court.
But the court also did announce that between 2013 and 2016, certain amendments had been made to the CI and so on and so forth. Does that not make its point mute? That
is the beauty of legal issues. You know, you might have raised your point and raised my point, but I need to look at what the Constitution says, the law says, and refer to the matter. So they have the right to come back. They have the right to come back, and when they come back, it also falls under the remit of the judges at the Supreme Court to look at the issue that he put forward, whether it has weight or it does fit into what they have already ruled. If not, they would take the decision. So that's the beauty of democracy and that beauty of legal matters. And as time goes on, we're seeing that these are issues that are being raised, coming up to enable us all learn along the road. And for me, it's a sign that Ghana as a country, we are moving on and we are developing as a country.
Okay, Barbara, thank you very much. Edward, thank you very much. And thank you also very much. Of course, some of those who have been coming to court include Madame Ikiadonko, who, of course, we know is one of the presidential candidates. She took part in the elections in 2020. She has also expressed a lot of interest in the proceedings so far. We'll hand over to the studio now for further the discussions to continue from there. Tomorrow we shall return at exactly 9:30 when the court starts sitting, but way before 9:30, of course, we will be back here, myself, Barbara Kuma, Edward Nyakon, to bring you all the analysis of everything that may have happened today and even after court today, and give you a peek into what is likely to happen in court tomorrow as well. Back to our friends and colleagues.
When we came to Supreme Court, they've made sure that the COVID-19 protocols are strictly observed. Let's say it.
Except for the fact that when the lawyers come out and the way the media rush to interview them, we disregard all of those. That was my major concern. And you find that at that point I didn't ask any question because I felt really, really unsafe because of the way we masked up around the lawyers. But I'm sure that as the days go on, we'll find more, decorous ways of going about these interviews and so on.
That we have to come with our boomsticks, and therefore we'll do the stretch, and then we can.
Exactly. Thank you very much. So back to the studio where George, Morris, and other colleagues are standing by. Thank you. We'll be back here tomorrow.
In studio, or we've been joined via Zoom by lawyer Dr. Kweku Ajiman-Budu. He's a lawyer, a law lecturer, head of Law Center's Gimpa Faculty of Law. Good afternoon to you once again, counsel.
Good afternoon.
Right, so what will you make of what's just happened at the final leg of the hearing?
I mean, we all saw what just happened. What happened was that the application which was made by the petitioner for leave to serve interrogatories on the first respondent was dismissed by the Supreme Court. So essentially the Supreme Court sided with the first respondent's arguments that these are matters that have already been dealt with, and it won't serve any useful purpose, if I can put it that way. That's not what they said. I'm just summarizing in my own words. And there was the argument that even amendments are not necessarily provided for under the rules, the CI 99, which amended CI 74 and CI 16. But the court, in its own wisdom, in the interest of justice, decided to allow those amendments that the petitioner sought to make. But with this application that was made, the court essentially suggested that these are matters that are not in dispute, if I may put it that way, because if you look at the rules that guided the conduct of the elections, these are things that are stipulated in the rules, CI 127, I believe, which was the public elections regulations. And so on the basis of all that, the court decided to dismiss the application and move forward to consider the issues that will be set down for trial.
Okay. Right. So given that it was a unanimous dismissal, does the NDC have the opportunity to appeal?
I mean, they said they wanted a certified copy of the ruling so that they will advise themselves. So let's wait and see what they would do once they receive that ruling from the court.
So when we come to court tomorrow, what exactly are we going to be doing? What is the case management process like?
Essentially, what what has to be done now, and that's what the Supreme Court essentially wanted to have done this afternoon, was the setting down of issues or the assistance of counsel for all the three parties to guide or help the court in setting down the issues that will be the tribal issues. And so, but unfortunately, counsel for the petitioner suggested that they were not necessarily in a position to, on their feet, come out with the issues for trial, but we saw that the respondents vehemently rejected that notion, suggesting that once you are coming to court during case management, pre-trial hearings, you need to know that the issues have to be set down for trial. And indeed, you are the petitioner requesting the invalidation, essentially, of the election results. And so somewhat it behoves on you to have prepared thereby. And these were the arguments that were being made by the second respondent, right. I believe.
So we are resuming tomorrow, 9:30 a.m. Does it appear that we're going to be sitting daily? Hello, Counsel, are you there?
Yeah. But I didn't quite hear your question.
I'm saying that the court will resume tomorrow. From where you sit, does it appear that we're going to be sitting daily for the expeditious adjudication of this particular case? Hello, Doc. Right, so I think we lost Doctor there. Yes. We'll try and raise him once again.
All right, so I think we'll leave, we'll end our coverage here and say thank you very much for joining us all the way from the morning into this afternoon. And before we wrap up, just so you know, try as much as possible to observe these safety protocols. It's very, very important. Put on your nose masks, wash your hands under running water with soap, use your hand sanitizer. Let's do this together. And at the end of the day, we can see how best we can kick out COVID-19. Let's adhere to these protocols. So on this note, thank you very much for joining us. We'll be back tomorrow at 9 in the morning. My name is George Sapo.
My name is Morris Ogbete. Thank you for doing the watching. See you tomorrow, maybe before 9:30.
Yes, right. Yes, before 9:30. Bye-bye.